Pardon to make a mention, my lords. Once,
Mr. Kuntia is no.
Pardon me, my lord. He's on his way, your lord.
Is he coming?
He's coming. Pardon me, my lord. Item 3, my lord. My lord, kindly one day time for rejoinder, my lord.
Monday. 1 month.
Item 23 matters will come in the next month. Here's the matter on 10th of October 2023.
Maybe pardon to make a mention.
You are Mr. Das who mentioned the matter.
My lord.
Mr. PCC Sanchapada,
My lord.
Land Council. Well, the matter of Mr. Census. Meanwhile, the petitioner may file the rejoinder if any no further recommendation will be made for the same purpose. Yes.
My lord. Item 1, my lord. My lord, here in this case, it's a covered matter. Against that original judgment, a review is pending, my lord. May I pray for a little accommodation, my lord? In the meantime, we will get the review petition disposed of. We'll try our best to get it disposed of. 2 weeks.
How the review?
I'll submit, my lord.
You are the appellant.
My lord, I'm the appellant.
Appellant filed the review petition.
Appellant has filed the review petition.
After the appeal is filed or before the appeal is filed?
Before the appeal is filed, it is a subsequent disposal of the writ petition wherein a certificate was given that no review is preferred against the original order which was said to be covered. Against that, actually review petition was already filed. So against that, we have come before.
We are not mentioning anything because there is a question of the admissibility of certain things.
My lord.
We are fixing on 10th of October.
Oh, bless.
Or more time do you require?
No, my lord. Within that time, we will try to.
You are Mr. Mohanty.
My lord.
At the request of Mr. H. Mohanty and counsel appearing for the appellant, let the matter be listed on 12th of October 2023.
Oh, bless.
But please, my lord, I don't
mention, your lordship. Your lordship, this matter related to the construction of village road. The state has partly constructed it and
It's out of list.
Just we are going for the page mentioning. Just wait for some time. Yes.
Page 2, item number 7 to 10. My lord, item 8, my lord. I have filed a miss case for withdrawal of the writ appeal, my lord.
Already filed.
My lord, already filed, my lord.
5986.
Yes, my lord.
The ground assigned in this petition is accepted. The applicant is granted leave to withdraw the WA number 447 of 2023. Accordingly, this application stands allowed in main WA. In view of the order passed today in item number 5986 of 2020, this appeal stands dismissed as withdrawn. Interlocutory application, if any pending, are also disposed of. You are Mr.
G.N. Sahu, my lord.
Mr. G.N. Sahu for the appellant. Anybody for these? No, okay, none appears for the respondent. Okay.
Page number 3, item number 11 to 16.
Yeah, item number 11.
Yes.
The writ appeal copy has not been filed despite the matter being taken up twice. A writ appeal copy.
Who is there?
Mr. Samal is appeal copy.
Mr. Tripathi, just to wait. Maybe he is coming. And today there is some dislocation also.
Item 11, I will show the copy, my lord.
Saw it, all right. We have not taken this.
Page 4, item 17 to 19. Page 5, item 20 to 22.
May I please, my lord, item 20, there is a personal appearance. As being lord should be taken over 12:30.
All right. 30 years.
Madam.
Item 21, your lordship. Item 21. On behalf of UC Misra, your lordship, 3 weeks time may kindly be granted to file rejoinder.
No. 2015 matter.
Your lordship, on August 1, government has filed counter. Your Lordship, he is suffering from severe cold, so he has a request to
Fixing the matter on 27th of September.
oblige.
And the request, you are there on record.
No, Your Lordship, on behalf of A. Misra.
What is your good name?
Debasmita Devadarshini.
The request of agencies. Appearing on instruction of Mr. Yusuf Misra, let the matter be listed at 27 September 2023. Meanwhile, the rejoinder even may be filed by the petitioner. Next.
Yes.
That 11 will be taken up next week. Please serving a copy today.
All right. Fourteenth, 11. Just again 11. So so when can these are 249 cases, means bulk cases. This 13/9 can it be 12/9 can be, I think 12/9. You come on 12th of September. We requested Mr. B.S. Tripathi and counsel appealing for the respondent. You know, for all the respondent, one respondent, let the matter be listed on 11th of September 2023. Or 12th of September.
Page number 6, item 23 and 24.
Maluk,
I am not registered to file this matter common late.
we're also appearing for 23, Maluk. 23.
What is your good name, sir?
Vivekanand Baishak.
The request of Mr. B. Baishak, counsel, appearing for the respondent. Let the matter be listed on 5th of October 2023. Meanwhile, interim orders passed earlier shall continue. What is your good name? You are there?
No, Maluk. Jayant Kumar Padi on behalf of Mr. Amit Prasad Bose, Maluk.
Jayant Kumar Padi and counsel appears on behalf of Mr. P. Bose and counsel for the appellant. Okay.
Page 7, item 25 to 27. Page 8, item 28 and 29.
May I be pardoned, Your Lordship, item 48 on behalf of Mr. Vachai.
1 minute, sir. Page 18, item 30 to 34. Page 19, item 35 to 40.
39 39 also kindly see the notice. See the partner matter. Last occasion also already had the matter. I pray on take up today. Already is the part of its part. It will take only 5 minutes.
39 called 12. 12.
Pardon, my Lord, item number 38. This is phrase application. I need some further time in this, my Lord. The phrase application, learned senior is there for the opposite party on caveat.
Okay. 5th of October.
My Lord. Oblige.
Item number 36, my lord. My senior is ill, my lord. Kindly taken up this matter next week.
What is the name of the council?
38.
36, my lord.
What's the name of the council is mentioned in the matter?
Item 38.
Means.
Mr. Estas.
Mr.
38 money. 38.
In Mr. Estas.
No, Mr. Estas. Estas.
You're Mr. Estas.
Pidas.
Pidas. Or then
Have you informed Mr. Rath
Your man.
All right.
Mr. Shah is there.
Or the request of Mr. P. Das and counsel appearing for the petitioner and the matter will is 5th of October. Of Mr. D. Roth and counsel.
Shah.
Yeah, Mr. Shah.
Ma'am.
That counsel is appeared for the respondent. Then just since Mr. A.K. and counsel has appeared, this caveat was earlier discharged? No.
No.
Caveat petition stands discharged. Okay.
Item number 36, my lord. My senior is ill. Kindly taken up this matter next week, my lord.
Who is ill? Who is ill?
SK Naik.
He will conduct the case or Mr. SSK Naik will conduct?
SK Naik, my lord.
SK Naik will conduct. Usually the matters are done by SSK Naik.
What is your good name? You are there on the court?
Your name, please.
Trupti Das.
T. Das.
The request to Ms. T. Das and counsel appearing on instruction of Mr. S.K. Naik and counsel, who is reported unwell. Let the matter be listed on 11th of October 2023. Yes.
Case number 20, item 41 to 48.
Item 48, may I pardon me, Lordship. On behalf of Mr. Acharya, I pray that matter be taken after 3 weeks as his mother demise has had demise.
You are Mr.
Yes, General. I don't have power.
Assistant General Counsel appearing on instruction of Mr. P. Acharya, Senior Counsel. Let the matter be listed on 18th of October 2023.
2 weeks, because your lordship has fixed it to today for hearing, but it is urgent matter.
Because he is on the.
I understand. 2 weeks after, first week of October.
Let it come. All right. Make it on 5th of October 2023.
My lord, item 44. My lord, item I am on VC.
State opposite parties. Yes.
Item 44, my lord. 2 weeks time for the filing of rejoinder. Counter filed by the OP number 2, but OP number 1 is not filed the inquiry report till today.
Let the matter be called. Let us see the record. Yes. Next.
Case 21, item 49.
My lord, due to some personal difficulties, I also filed an rejoinder.
All right. Let us see. Let the matter be called out. We have to see the record. Yes.
Case number 22, item 50 and 51.
Item 51.
Yes.
Item 51, Your Lordship directed the appellant to file an affidavit. Let I pray 1 week more time. Let to next Monday it can be taken up. In the meantime, I will file the affidavit. The Development Authority matter which was hearing the letter.
All right. The request of Mr. B.S. Panikir and counsel appearing for the appellant. Let the matter be listed on.
This side. This side.
No, I'm asking him. Yes. 26th of September.
My lord, I don't know 50, my lord. My lord, afternoon 50 kindly taken out today, my lord. I don't know 50, my lord, kindly taken out today, my lord.
Yes, both the parties are available. We will take up at 12:30.
12:30, I always me.
Page mention 1.
If I may, pardon to be make a mention, Your Lordship, read appeal number 1149 of 2023, Your Lordship. It is the Truck Association election matter. Your Lordship, specific direction was to list the matter today, Your Lordship. An interim order was passed. But for the reasons best known to the registry, it hasn't been listed today, Your Lordship.
So what do you want?
Matter may be listed, Your Lordship, and it may be finally heard, Your Lordship.
Will you come again on 12th of September? 12th September.
Lordship, the matter, the election is posted for 24th September.
12th we are taking up. Because a lot of intervening holidays are there.
Yes, Lordship. It's a matter of exigency. Otherwise, I would not have pressed.
Come prepare 12th, trying to inform the other side. Is the matter in seconds? There is no, not on board, no? Already.
Be permitted to mention.
This is a CMAPL, my lords, arising out of a repetition where there was interim order stay, GST matter. Now it has been dismissed and the bank account has been attached. It was disposed of by your lordship's predecessor sitting with Honorable Justice Raman. So should make
Just to take to the DS bench with Raman.
I
I
mean,
may be permitted to mention one matter.
May I be pardoned to mention, Your Lordship?
My lord, there's a 3 writ appeals, my lord. Those were directed to be listed 2 days per the last order. The vehicles are lying, my lord, deteriorating every day. They are lying for a year. Writ appeals 1702, 1703,
Send a memorandum, because we can forget, we can bring the wrong first.
I'll do it, my lord.
All right, all right.
Tomorrow, my lord, at least.
All right.
May I be pardoned to mention, Your Lordship? Your Lordship, the matter related to the construction of village road. The state has partly constructed it and the other part is in a dilapidated condition, Your Lordship. And for which there is a difficulties for the vehicular movement. Your Lordship may kindly take up this matter any date.
Yes, she's on 22nd.
The case number.
Where is your memorandum of the case number? How will follow it?
PIL number 23980 of 22.
There is no PIL number in this. That must be WPC PIL number.
Yes, Your Lordship.
Repeat it again.
23980 of 22.
And also say, file a memorandum of this mention.
2022.
Yes.
What is the sudden urgency?
Due to the vehicular problem, there's a movement for the vehicular problem, Your Lordship.
All right.
Okay, let it go to your October.
One press CM for restoration of the REIT application, lordship. Press CM application.
This will come automatically. This will come. Take the list.
This is regarding the REIT application before Your Lordships on 28th. It could not reach and Your Lordship has posted it to 12 times. Can I pray for an earlier date?
Well,
Should the respondent is deprived of a promotion since 2021.
it is only on the 12th of October. This is very close. Wait for till the date. Yes.
It's a PIL in nature. Grace admission matter.
Take.
My lord. My lord, it is a review petition arising out of a writ of SUBHASIS Act. My lord, the judgment was passed by Justice Jaswant Singh and Justice M.S. Sahu. My lord, Your Lordships, I had mentioned it earlier 2 times. Your Lordships had directed me to go to the Registrar Judicial, but the bench has not been constituted and it has not been listed.
All I give the list. We'll go back. Justice MDR. Justice Sarangi and Justice Raman. Because earlier then Justice Raman was a member.
Justice M.S. Sahu, sir.
Miss Sahu. Okay.
My lord, I'm appealing person. So this is a review petition arising out of street appeal number 149/2007. So I have been terminated since 2002. So the review petition is taken up with the whole issue.
Yes.
On 8th of September.
No. Just we cannot give you the date because it will go to another bench.
So it was previously that means taken up the Chief Justice and Honorable Justice K.R.
No particular date will give now. Just follow this. We'll give the date. Because we have to adjust so many dates and then we'll only give the date.
Short date may kindly.
Short date will be given.
Something not like move.
All right.
May I call the list? Weekly daily list item number 2.
But in this case, the issues involved in this case squarely covered under the Orissa State Abolition Act 1951.
Yes.
But state abolition matters are division bench matters. But inadvertently, it has been decided by a single judge. And against that, the present rate appeal.
You are also party in that proceeding?
Huh?
Were you party in that proceeding? Why are you party in that proceeding?
So I was advocate in the case. In the read petition, I was engaged as an advocate.
So it was the petitioner's mistake to approach a wrong jurisdiction. It is the petitioner's mistake there to approach a wrong jurisdiction. If you now contend that the single judge did not have the jurisdiction despite that the final order has been passed, we will not allow you because you yourself has filed, given to that jurisdiction. Now we are raising this issue here. Except jurisdictional point, you may argue on other points.
It was my humble submission is it has been inadvertently decided. But state abolition matters, it matters.
All right, we'll look into this.
This issue was also not brought to the notice of the Honorable Single Judge because he was the lawyer. The petitioner was my learned senior's wife, and he never raised this issue. He participated in the hearing.
So the decision will stand. The division bench matter.
All right, we understand it. We understand it. Now you are coming to this court and saying after the final order was passed, as if suddenly you have come to know the law. Is it the case that you did not know the law earlier when you approached the learned single judge? It is our decision, what decision we will take now. I'm just pointing out, we will not allow you to take the ground. You have pointed out, that's all.
What has happened?
Yes.
The Honorable Single Judge has decided.
Yes.
It was under confusion that writ petition has been decided by the Honorable Single Judge.
Just you argue on the merit of the appeal. Why you should?
So far merit is concerned,
Yes.
the petitioner in the writ petition was the purchaser of a piece of land from the absolute owner of the land.
Yes.
So how he has become absolute owner, to the Lordship know, Orissa State Abolition Act came in 1951. All the intermediary interests were abolished. But the tenanted lands and the tenants are protected under Section 8(1) of the State Abolition Act.
Yes.
I place Section 8(1).
Yes.
Any person who immediately before the date of vesting of an estate in the state government was in possession of any holding as a tenant under an intermediary shall, or from the date of vesting, be deemed to be a tenant of the state government, and such person shall hold the land in the same rights and subject to the same restrictions and liabilities as he was entitled or subject to immediately before the date of vesting. But this being the provision of Section 8(1), the estate has been abolished, but tenants who are tenants under the intermediary, they continue to be deemed tenants. Their interest is not abolished. Therefore, the vendor of the petitioner, writ petitioner, has purchased from this tenant who has been recognized by the Orissa State Abolition Collector. That means the Tahsildar concerned, who acted in dual capacity as Tahsildar and the State Abolition Collector, has recognized the right of the vendor of the petitioner. And that has been filed in the writ petition as Annexure 2. That is the information submitted by the OEA collector that the vendor of the petitioner has been recognized by the OEA collector as a tenant. And he becomes the tenant directly under the government.
Yes.
Thus, he has become the absolute owner. And from him, the petitioner has purchased. But what has happened? The Honorable Civil Judge has failed to apply this provision, and by mistake, he has applied the provisions of the Orissa Hindu Religious Endowment Act, wherein the Honorable Civil Judge has said, since it becomes the property of the deity, permission under Section 19 is necessary, and if the deity is a private deity, it has to be declared as such under Section 41 of the Orissa Hindu Religious Endowment Act.
Yes.
But that is not necessary. My humble submission is, Orissa Hindu Religious Endowment Act doesn't apply to the present case. This is squarely covered under the Orissa State Abolition Act, as because the vendor of the petitioner has been declared as a tenant under the Orissa State Abolition Act much prior to the declaration of the deity as a public trust by the specially constituted tribunal under Section 8D of the OE Act. Now, on Section 8D of the OE Act, a tribunal has been constituted and which has been empowered to declare the deity as a public deity. And the purchase of the petitioner is in 1980. The declaration as a public deity.
What is the date of transfer by the present appellant?
The date of year of transfer is 1980. Date of transfer is 27/6/1980. 27/6/1980.
And when the land was declared as the deity's land?
No. By then, land was not declared as a deity's land. Deity's land was declared in 1995 by order of the OEA collector.
Just add, this is a page 31 of the writ petition. Page 31 of your writ petition. Come to this order.
Yes, well, page 31.
You come to the just last but one paragraph. Last but one paragraph, the line starts with the suit land is the deity's land.
Wait, page 31 of
writ petition.
Writ petition.
Writ petition.
This paragraph of reference has been made to the letter of the Endowment Commissioner.
Paragraph
last but one paragraph.
23, paragraph 23.
No, there is no paragraph. I am reading from the page 31 of the writ petition.
Page 15 of the writ petition.
These are part of the annexure 5 of the writ petition.
Annexure 5 of the writ petition.
Come to this Page 31.
5 is 31. Pencil.
Yes, Pilot. Page 31. The last but one paragraph. The paragraph starting with the display is the date is land.
It is land. But that is this order
has been challenged.
Yes, sought to be quashed. This order sought to be quashed.
I am asking about what is how this letter that was issued in 6th of September 2002 is a commissioner's letter. Commissioner's letter is a communication of the order already exists in the record of the endowment office.
No error. By then, sale purchase was in 1980. By then, DT was private DT.
That is the one.
DT.
That is the crux. He is saying that by that time it was a private DT, but the single judge is that even if you say that it is such a declaration is mandatorily required under Section 41.
Section 41 is not required.
Because subsequently it was decided that for private DTs it is not necessary. That was decided subsequently, if I am not mistaken.
No, it is
a decision of this court.
In another case. But so far as this particular matter is concerned, that this was a private DT could not be proved by the petitioner. And even
that on the same ground that the single judge, without entering into the merit, we admit this appeal. I think there is something to be heard. Because basis of the order of the letter of a commissioner, and that cannot be the basis. If someone has to say, she must show the declaration has been made.
Yes.
Then the declaration would be the primary document.
That is the primary.
The letter of commissioner. Entire order of this settlement is based on the letter of the commissioner. They should have asked for this original declaration or the records that is maintained in the office of the commissioner of endowment.
To ascertain which is the date of declaration.
Exactly. That is very important because according to Mr. Cole, what has happened during this
salary was executed.
Vesting, the other property vested in the government, only the tenant's property was not vested directly through payment of some fee. They call it a fee.
Salami. Yes.
They have been made this tenant. And the state is the superior owner. But so they have a right to transfer. If that is the situation,
that is his case. But the opposite party's case is that it was never settled in favor of the vendor of the petitioner. Rather, DT was declared to be the settled lawyer.
So the tenant did not file any return. Did not file any return.
That is the view. I have no record. But what I find from the impugned judgment, which is the Honorable Single Judge has, you Lordship, hear it on merit.
That is wrong, my lord.
Alright.
As per Annexure 2, the OEA collector himself has replied that the land has been, that the tenant has been recognized.
And prior to 1980, Lordship has pointed out last date that he has filed a review petition. Whether the appeal is maintainable when a review petition is pending. That point your Lordship has raised.
Mr. Court, that I am finding
he has to answer that.
Terrible practice in this court. Someone is filing review petition and then coming to the appeal.
The review petition is under active consideration of the Honorable Single Judge.
And I am, according to you, both you can take both the votes together.
No, I don't dare to say like that.
You cannot say because the law prohibits you.
And I think review is first filed.
When you file a review petition, precondition of such filing is that you have not filed any appeal. Read Order 47 Rule 1 to gather the principle.
Well, let me then, I pray, let me be allowed to pursue the review petition. Let it lie over some time.
Yes,
because when a question of maintainability is allowed, we cannot allow someone to live over.
If he intends to pursue the review, then he has to withdraw this. This is very simple. He has to withdraw this writ appeal.
Again, it
will come, question of limitation will come. For that,
no, we cannot allow both the things go simultaneously. That is as simple as that. What will happen to this writ appeal? We are admitting it, and a review judge will learn a single judge on the question of jurisdiction reverse his own order. We will not invite this kind of situation.
Two courts examine.
but if the
Yourself, it is not a mere question of jurisdiction. Yourself has styled this petition as the Article 227. Well, your writ petition is also filed under Article 227. Your writ petition has also been filed under Article 227. Do a division over the jurisdiction
226 and 227. When it was the Supreme Court decision was not there.
No.
It was filed before that in 2010. It has been
I am
filed.
telling you, the Supreme Court decision of 1973 was there. That if a petition filed under Section 227, no writ appeal lies.
Well, this is a petition. This writ petition has been filed under 226 and 227.
And that is also, you are not sure what is the jurisdiction. If it is a 227 petition, this division bench doesn't have any powers. Even you cannot also file a writ appeal.
My humble submission is the writ petition was under Article 226 and 227.
That is why I am asking you, it is also under 227. The moment you file a writ petition under 227, this court's jurisdiction is barred.
That I know, my lord.
Then
This writ petition is not under 227, Article 227.
you have yourself written it. You have not written that it is writ petition under Article 227. Should I see you this your writ petition? Come to the writ petition page. It was filed on 21 April 2010, and just see the first cost title.
It's 226 and 227.
That is why the moment you write it is also a petition under Article 227. How this court can entertain a writ appeal? How? Tell us. Show us the way. We are ready to hear you on merit.
My humble submission, by the time this petition was filed in 2010, this the position that has been decided by the Honorable Supreme Court.
That is regarding the jurisdiction of Article 226 and 227.
Yes, my lord.
But in 1973, Supreme Court decided any petition filed under Article 227 will not be amenable to intercourt appeal or letter patent appeal before the same High Court.
My lord.
So if you still insist, and I read your the petition, it appears that you filed this petition under Article 227 because you are challenging the order of these settlement authorities.
Board of Revenue.
That is the settlement authorities.
And let him decide whether if he pursues the review petition, then he can withdraw it with a liberty. But that point is more important now.
May I pray for deferring this matter for a week? So that
we can defer time and again. Last occasion also we deferred it. You are raising the same issues as before us already. Mr. Mohanty giving a long date, let them decide it.
Well, this point was also discussed last date, and he.
No, that is why I am telling Mr. Kaur.
That only maintain whether this appeal.
No, this was not discussed.
How
in 1995, my lord. In 1995.
On 1/8/2023, the order was passed. We are apprised that the appellant has filed a review petition challenging the same judgment which is challenged in this writ appeal. Let the appellant take a call in which forum he would pursue the remedy.
That is what I am saying. That is an order.
Your order was passed on the last occasion. Because we will not allow you to pursue the two forums simultaneously against the same judgment. It is called the abuse of process of the court. You are not sure where to go. And court is not here to counsel you, learned counsel.
No, I'm
sorry that we are showing so much of leniency. Our duty was at the threshold to shut down this kind of appeal. I will only pray for a week's time. No, then it will go to the 19th of October. Let the matter be listed on 19th of October at the request of Mr. Surendranath Kaul and counsel appearing for the appellant. Mr. Kaul could not. Mr. Kaul did not submit anything in regards the order that was passed by us on this order is not uploaded. Well, it is not here. No, it seems that it has been. Order number 2 is the 24. Oh, sorry. It's a different order. Order number 2 is. They didn't make any submission in respect of our order dated 1/8/2023. He prays for further accommodation. At the last opportunity, let the matter be listed on such and such date, 19/10/2022. Mr. D.K. Mohanty and additional government advocate has appeared for the respondents. Item number 4. Your better recourse would be, Mr. Kaul, I am telling you, you have rightly filed a review petition because inherent error is apparent on the face of record, as you say.
Well, the order is fully wrong because the.
No, on merit, you will not make a single observation. Regarding jurisdictional issue, you pursue the review petition. All right.
Had it been under Article 227, I would not have pressed.
No, this alone. Why you should at the threshold decide what the jurisdiction under single judge is exercised? Usually now the law has changed. You know that. After Radhesham and subsequent 3 more decisions, they have confirmed.
Radhesham came much later. It was filed.
Always much later doesn't mean in a pending matter we cannot apply that principle. Court can always apply this principle. The matter has not been decided already. So court can always, when this is an issue of the jurisdiction, court can remit you back to the appropriate jurisdiction. It's all right. Item number 4.
4. 3 adjourned. 3 adjourned.
Item 4. Give a date. Any shorter date? Give a date. 26/9. List on 26/9. There's none appears for the petition. Item 5.
Item 5, may I come in, madam?
First shall be made for recovery of the victim girl. So a copy of this order is supplied to Ms. Patnaik and additional government advocate. Yes, next. Item 6.
That item 6, Milord, has come. Petitioner since custody, Milord, 11/5/2009, Milord, and he has been convicted offense under section 302 of IPC for killing his wife, Milord. And on the sudden provocation, on filing the.
Now the petitioner counsel is here. Very good. And we can have the matter.
Take the matter at 2. There is 2 o'clock. This one, 20. All right.
It's a short point. It can be
all right.
All
right.
My lords are directed to list the number of parks that are in the management of the CMC and whether any construction has been built. None that. He's here.
So I thought maybe he's going to address the court in person.
Okay, item 50. Yes.
Let me recapitulate the last. But I have framed a question of law that whether this honorable court can issue direction to the state government to fill up the vacancies available from out of the panel maintained by the chief engineers and engineer-in-chief of Orissa in view of observations made by the Honorable Supreme Court in Anurag Sharma versus State of Himachal Pradesh. The facts are like this, manner. Prior to amendment of the recruitment rules, a merit list for diploma was prepared and the vacancies were filled up from the panel. It was amended on 5/1/2013. But while notification, they kept in abeyance up to 31 March 2014. Subsequently, also it was kept in abeyance till 2018. In the meanwhile, the Orissa Staff Selection Commission has issued a notification in advertisement filling up these vacancies. So we approached the tribunal that these vacancies belong to us, so this should be given to us. The Orissa tribunal decided this matter on 26/4/2017. I'll invite your lordship attention, page 38 of the W writ appeal. The para starts the first part of the rule. If you leave 6 lines, on a conjoint reading of the entire rule, the conclusion would be that even though the resolution which was in force was repealed, but the list which has been prepared under the resolution is to be treated as valid and in force, and the government at its discretion can utilize the list as has been done by sponsoring the names of some candidates as per letter 33/2014 pursuant to amendment of rule dated 5/10/2013. Before seeing the conclusion, kindly see page 85. Yes. Last para, whereas the process of recruitment for Orissa Staff Selection Commission shall take at least 6 months, that is, state government cannot afford to wait for 6 months to fill up these vacancies, since it might seriously affect the implementation of infrastructure projects. Now, therefore, in exercise of powers conferred by Rule 19 of the said rules, and in exigency of public interest, the government, after careful consideration, do hereby relax the provision of the aforesaid rules till 31st March 2014, and as such, all appointments to the existing vacancies, kindly mark this mirror, existing vacancies of junior engineers shall be made as were being made prior to commencement of these rules, that is, from out of the panel maintained by the Committee of Chief Engineers, Engineer-in-Chief, Civil Orissa.
All right.
Tribunals order was challenged before this honorable court, before a DB bench. The observation of this honorable court is page 48. In our considered opinion, the tribunal, while making such direction, has committed error in not ascertaining the vacancy position as of 31st March 2014.
What is the page?
Page is 48 of writ appeal. Have you got it? Sorry, page 48.
Got it.
Para 8. Keeping in view that petitioners are eagerly waiting for adoption since long, Government Chairman held that it is desirable that government, being an idle and model employer, may take a decision as one-time measure and consider to relax the relevant provision under Rule 2012 for appointment of the applicant, and for that purpose, if necessary, may fix certain quota in future recruitment. In our considered opinion, the tribunal, while making such direction, has committed error in not ascertaining the vacancy position as on 31st March 2014. Further, the materials now produced before us, in view of exercise made by this court, Government Tribunal should give a relook into the matter, and this matter was remanded by the time State Tribunal has been abolished. These matters came to single judge of this Honorable Court. Now they have find out that there was total vacancy of 2773 up to 31st March 2014.
2,773.
2,773. And writ petitions were hardly 180 or 200 before this court. Now, Ramaya and others has been overruled. The latest judgment which I handed over last time, that is on Raj Sharma. At page 56, they are shown 8.5. Second, the third is important. The government is entitled to take a conscious policy decision not to fill up the vacancies arising prior to the amendment of the rule.
Not scanned.
Copy I have given last time.
Receive the judgment.
Civil Appeal number 9746 of 2011.
Well, I am supplying them.
Do you have the copy?
I have got 2 more copies.
That's right. Yes.
Page 56.
Is it part of paragraph 35? Part of paragraph 36.
36. Yes. 3. Proceed. The government is entitled to take a conscious policy decision not to fill up the vacancies arising prior to the amendment of the rules. In our case, there was a conscious decision to fill up the post by taking into consideration the old rules. Now, number 5. When there is no statutory duty cast upon the state.
Now, there is a distinction, Mr. Yes, yes, you have to find out this distinction that the government is entitled to take a conscious policy decision not to fill up the vacancies. We are not in a case not to fill up. We have to fill up the vacancies. And your only objection can be why under the old rules. That can be your objection. But the Onurag case is not regarding whether the old rules or the new rules.
No, is the entire is because Rangaya, Deepak Agarwal, those were discussed.
But the finding you just see. The findings are in paragraph 36.
Yes. A review of 15 cases that have been distributed, Sangaya, would demonstrate that this court has been consistently.
Only para 2, subpara 2 of para 36 is the material.
Subpara, it is now well settled proposition of law that a candidate has a right to be considered in the light of existing rules, which implies that rules in force as on date of consideration takes place. The right to be considered for promotion occurs on the date of consideration of the eligible candidates. But in our case, whatever they said, till the existing vacancies are filled up, you follow the old rules. Then 5 also, when there is no statutory duty, whereas in our case there is a notification.
This decision, that for the word used by the Supreme Court is the existed rules. First of all, there is a distinction between the extant rules and the existed rules. Existed rules also includes the rules in the past.
That is Deepak Agarwal's observation, Robert.
No, this is the formulation in this judgment. Deepak Agarwal is a material of reference.
Yes. If you also see page 47, para 26. It is by now a settled proposition of law that a candidate has a right to be considered in the light of existing rules, which implies the rule in force on the date of constitution took place. There is no rule of universal or absolute application that vacancies are fulfilled invariably by the law existing on the date of vacancy arises. The requirement of filling up old vacancies under the old rules is interlinked with the candidate having acquired a right to be considered for promotion. The right to be considered for promotion accrues on the date of consideration for eligible candidates, unless, of course, the applicable rule, as in ROAC, has laid down any particular time framework within which selection process is to be completed. In the present case, consideration process. Now, para 28. In our opinion, the matter is squarely covered by the ratio judgment of this court in Dr. K. Ramalu. In the aforesaid case, the court considered all the judgments cited by learned so the facts and circumstances of the case. It was observed that for reasons german to the decision, government is entitled to take a decision not to fill up the existing vacancies, which is not here.
Here is just the reverse situation. Government has taken a decision to fill up the post. Your grievance can be that why they are applying the old rules.
Yes.
Why should apply the exact rule? Means the rule in force now.
Discrimination also.
That is why I am coming to that question. It is the government's discretion whether they want to do some benefit because of long stagnation of not promoting people. They think that we apply this for the vacancies while it was there, and we will apply for that. At that point of time, the last vacancy arose under the old right. You did not mature your right to be considered. If you had a right at that point of time, you will be also considered.
There were 445 vacancies, but they did not fill up. They did not.
There is a deprivation. You can also attack that whether this is a reasonable classification or not. Because the persons who are guided by the old rules, they distinctly make a class. The others, those will be considered under the new rule. And in that class, the earlier employees also will be considered.
But in 2018, from the same panel, hundreds of posts were filled up, applying the old rules.
Yes.
Because of the tribunal's order. The even law department say it is not correct, because once now amendment has come, you should not fill up the vacancies from the panel.
Yes.
But they filled it up. So we should not be discriminated. Now, how many? I think 48 persons are here.
True, because there is
and vacancy is 2,773.
Give the copy of the writ petition is not.
Actually, the relevant bit is time and again I have mentioned, but we'll also say if it is in the High Court, we can call it for 8877/2017. Which is 1237. Molkota. Yeah.
come to the decision of the learned single judge.
Yes. Single judge says there was no requisition and you cannot compel the government to fill up the vacancies.
That's true. You have no right to get promotion. You have a right.
No promotion. Absorption, appointment.
Yes.
Because even if that file is not before my lord, so I can cite 2000.
Yes.
There were, my lords, I am in the next item, that is 1237 of 2022. Along with that case has come. I didn't know that a mention has been made. Otherwise, my lords, but I could see from the board that
I have not mentioned.
I don't blame you, sir.
Have you not informed the council involved it? Otherwise, how they will not? He'll come and the matter should be taken. Because all the time I am requesting the council, whenever you make a mention in the early part of the day or sometime, your first duty would be to inform the council who is appearing for the other side.
Other side,
so that I could come prepared.
I don't believe that you are not prepared. You can say that you don't have the material instruction. That may be the problem.
My lord, as your lordship said, I cannot have anything to oppose.
So what, Mr. Patel, tomorrow can we try again?
Because I am seeing your board and I cannot.
Tomorrow many matters are there. Your lordship can.
And tomorrow there will be half day.
So my lord, it will not be fixed to tomorrow. Any day. Next week.
No, because the matters earlier occasion also I heard Mr. Patel in at length. Now today also he has.
Yes, my lord. Only very short point that vacancy, admittedly vacancies are there.
14th. Can you come back at 2? Can you do it today?
3 matters are after lunch.
Sir, after lunch, sir, I'm sorry, my lord, I'm in other matters already fixed up. Otherwise, I would have taken adjournment earlier in other course.
I doubt it there. We'll keep it as a partner on 14th.
14th, yes.
Heard Mr. K.K. Patel and the council appearing for the appellant in part for continuation of hearing that the matter was listed on 14th at 12 p.m. Mr. M.K. Kuntial and additional government advocate. Still in other matters, this is the new ground council. Both the matters is.
Looking at your board, I had no courage to see if we see on this day or that day.
May I have my lord's kindly, my lord, item number 40, Mr. Pal is appearing for opposite party number 1. My lord, can I pray that if it can be taken up at 2 or before rising, if it is convenient, lordship?
We'll come at 2.
Lordship, great.
My lord, they are not hard copy.
My lord, he has entered appearance after taking a copy from the department. I submitted in department.
Well, let us see the status. Yes. Come at 2.
Great,
Lord. Yes.
My lord, item 18. I am for the cavator, my lord. I request my senior to serve a copy of the writ appeal so I can be taken up next week.
I'll serve in course of the day.
So discharge the caveat and it may come on some other day.
11th, my lord.
11th is not possible. 22nd September we may try.
My lord.
I'll serve in course.
There is the item number?
Item 18.
Mr. D.N. Rothland Council has entered in the appearance from the respondent. Earlier, the respondent had lost caveat. So we request Mr. M.K. Kuntial and additional government advocate appearing for the appellant to supply a copy of the appeal along with the miscellaneous applications to Mr. Roth and counsel in the course of the day. Caveat is still there. Stop. In view of the above direction, caveat petition number 134 of 2023 stands discharged.
22nd.
22nd.
No, item number 29.
26th. 26th.
Item number 16, which was there on Saturday, madam. The lordship indicated to be taken up today as 2 o'clock, but there was no indication about 2 o'clock. And now you know,
Let us see. But inform the counsel of the other side.
Yes,
State the appellate, right?
Item number 29. Similar orders has been passed, restoring the matter to single bench to hear it once again.
Similar orders means?
Has been passed. Directing the single bench to take up the case, restoring the matter to the single bench to take up the matter after filing of counter by the state government.
Perhaps he is appearing in one of the that is batch of cases.
I'm appealing for two in the two cases.
Others may not agree to that proposal.
Exactly. That is why you can't better let the other counsel appear before us. This matter, there is no general issue will apply to all the cases. All right.
My lord, I may be kindly pardoned to mention, my lord, item number 13, my lord, that orders matter, my lord. My lord, may I pray your lordship, this is a very small matter regarding delay condolation, my lord. The impugn order is no more existing, my lord.
We'll take up the matter if you want today, that after the fixed matter at 2, to be there, we'll try to take up the matters.
May I request your lordship that let it be fixed any other date, my lord. Today I have some difficulties, my lord.
Okay, given 14th of September. Oh, okay.
Okay.
Yes.
Item 19.
Please, my lords.
Yes.
I know your lordship has looked into the matter and has passed an order. I just want to state 6 points from a totally different facet of the successful resolution applicant who has in fact taken over. Those facets are a little important in statutory terms and established case law. I'll be very pointed with this. I know your lordship has dealt with the matter. But those facets may not have been put in quite the same way in terms of the impact of IBC and how your lordships can balance the equities. My submissions are being made in 13230, which is the clarification IA, and there is an identical 13222 for implement formally, because I am the successful implementation resolution applicant called JSW, and your lordship will need to see only some judgments and this IA 13230. And let me very pointedly tell you what those 6 points are. My first respectful submission is that whatever there, as your lordship knows, roughly 3 parcels of land. One is 0.533 hectares, approximately. I'm not giving your lordship the exact thing. .533 hectares. The second is 35 hectares. Yes. And the third is roughly 195 hectares. Really, your lordship is, of course, not concerned with the third, which is private non-forest. The second also, has no booked cases of alleged encroachment. So really, your lordship's focus was on 0.533 hectares. Now, it is common ground with everybody, the PIL petitioner, the state and us. That was, we are in the unenviable position of being a knight in shining armor, which has come from outside to save this company, to rejuvenate it, to have an agreement with the state of Orissa to supply on demand guaranteed X% of our output of power, to provide huge employment, etc. And that everything which is allegedly culpable or will be found culpable ultimately has admittedly all been done by the predecessors, the CD, who has been taken over. That your Lordship is aware of. So it is not that I have done any of this and I don't need to support it or explain it or justify it as something which I ought not to have done. Now, keeping these two facts in mind, kindly see 2 or 3 things. One is, and before I come to that first one, one more preliminary point. Ultimately, all such exercises rightly for environmental sustainability, for environmental protection, are all balancing of competing public interests. Your Lordships, as in life, so in public interest law, really balances competing public interests. There is no absolute public interest either way. Now, I am going to suggest a way in which your Lordship's legitimate concern for public interest is balanced without any harm or damage. So the first of those 6 points are that your Lordship's has got statutory and delegated legislation provisions for regularization of the infraction on point 533. Directly providing for such a contingency that something wrong is, and of course, those are worse cases because it is applied for by the person who has done it. I am the innocent party who has now taken over. I have not done it, but it is available to do. Now, the reason why it's important is that I can understand that till such time as your Lordship statutorily has a decision on those, I still use or benefit from or act upon these lands. I am starting because I understand your Lordship's legitimate concern about public interest, and I understand that your Lordship needs a very satisfactory explanation as to how, if your Lordships were to hold your hands for a while to allow the statutory process to work out, your Lordship would not countenance any damage to the environment in the meanwhile. So, while the regularization process is working itself out, I have, in fact, without instruction, but also I've got instructions. There is no question of touching these lands of 0.533 or what has happened in the hoary past. There is no question of my doing any fresh activity of any kind to assuage any apprehension my Lords may have. That's one thing your Lordship will keep in mind. That too coming from a person not responsible for that state of affairs. Now, just turn to your Lordship's order of this Honorable Court, the Honorable Division Bench of this Honorable Court on 17th May 23. And I'm going to respectfully suggest that your Lordships could allow this process to work itself out. Starting with this order, please turn to page 293 of the IA, which all the IA pages I'm giving are of the first IA, which is 13232. The one for 230. The one for relief, which I'm claiming. So if my Lord will turn to page 293 of the order of 17th May. Yes, it's a very short order. The grievance made by so-and-so representing JSW Energy, which has taken over the management of the opposite party, that is the CD, pursuant to the orders passed by the NCLT, is that unless the application by opposite party 12, now mark this, the application by opposite party 12, that is the entity, the company concerned, for diversion of forest land is considered by the state government, it cannot comply with the requirements and proceed to start its operations. It is suggested that the consideration of the proposal can be without prejudice to the rights and contention of the parties and be made subject to the outcome of the present petition. The above submission is not opposed by learned counsel for state. It is accordingly directed that the proposal submitted by the opposite party for diversion of forest land be considered in accordance with law, and after hearing learned counsel for the opposite party, a reasoned order should be passed in that regard not later than 1st of July. Now, this was a pending state of affairs. Now, 2 points here. One, it is not, forget this case for a minute, forget this case. Well, there are many activities of a developmental nature, factories, roads, plants. Forget this case completely. Where your lordship comes across a imminent public interest need for development, which is, if I may use the word wrongly, perhaps in inverted commas, obstructed or met by a forest area. It is for that reason that diversion of forest land is not a crime. Because lordship knows diversion of forest land has a lot of other compensatory aspects which are required to be fulfilled before you can divert. So you do have an escape route where it is considered imminent. Now that is done by very high powered authorities. It is done under regulatory scrutiny. It can't be just done casually.
But we did not find any affidavit that what has happened after 1st July 2023.
Therefore, I am still coming to that. Just turn to the recommendation. Now, it is not that it's my imagination that I will apply, and your lordship rightly may think it's a useless case, no possibility. It has been followed with a very important order of 13/6/2023. Kindly turn to that order at page 317. And this is by the highest authority. It is actually, it reports to the Supreme Court frequently, the Empowered Committee or the Regional Empowered Committee of the MOEF. And these are bodies which are very heavily under Supreme Court scrutiny. See that order at 317. If my lord will turn to paragraph 4. So there has been progress. And I am quite happy because I will suffer if it's a rejection. I am just saying your lordship may not consider making a fait accompli, which is irreversible, before this has worked itself out. That's all I'm saying. I am not saying that your lordship will do this way or that way. I am saying a order by as high an authority as the High Court will make it irreversible and a fait accompli. What happens if I get this permission shortly? Now turn to paragraph 5 at page 317. Paragraph 4. In the order of 17th of May, the Honorable High Court of Orissa directed, your lordship is quoted there. The proposal is placed before REC with the reply of the state government for further consideration. And then, paragraph 12, your lordship will come to. Actually, the relevant paragraph is 13, 14, 15, but I'll read all ones. Just come from 12 onwards.
Yes.
The project area does not form part of a national park, wildlife sanctuary, biosphere reserve, tiger, elephant corridor. There are no rare endangered plants or animals seen in the proposed forest area for diversion. That's an important aspect of public interest. State government has reported there is provisions of maintaining a green belt over an area of 317 acres. Thus, in order to address the issue, conservation of wildlife available in the area, a site-specific conservation plan is required to be prepared as per guidelines by the CLC Orissa, which shall be duly approved by the Principal Chief Conservator for its execution of the project as well as the project impact area at project cost. There is no protected archaeological heritage site, defense establishment, or any other important monuments located. State government has reported that as per DFO, so-and-so site inspection report, no displacement of human habitation is involved in this project. As per report of Tehsildar, the people of ST, Scheduled Tribe community, who were residing illegally over the plot 181, having an area of 1.08 hectares, etc., having Gramya jungle, have since vacated the land and have been rehabilitated and rehabilitation colony constructed. In compliance with the provisions under FRA 2006, the user agency has furnished certificate documents issued by the collector in respect of 34 hectares of forest land involved in this project, only out of 35 hectares of forest land proposed for diversion. The Pali Sabha resolutions passed, etc., have been furnished. The project proponent has already obtained environmental clearance for this proposal power plant, dated so and so. The SP Orissa has also consent to establish, etc., the whole thing is given. Then there was compensatory afforestation is 17. In lieu of 35 hectare forest land, incidentally, the alleged encroachments on 35 are not booked encroachments. The booking or the registration of cases only on the 0.533, not on the 34. In lieu of 35 hectare forest land proposed for diversion by the user agency, state government has identified 36 hectares of non-forest land in so-and-so name for compensatory afforestation, the GPS reading is furnished. Tehsildar has furnished non-encroachment and non-encumbrance certificate for the identified non-forest land. Then there was 324 straight away to end this thing. What is the final? This is what my lords asked me. The Honorable Chief Justice asked me this first. First note was 322. So it's a very detailed consideration. The authorities are working. It is not that there is any abdication by anybody. 322, the Lordship may not read. Just note down para 2930. 2930. Everything is noted, including the PIL. Now come to the decision in the last page at 324. I hope I'm not going too fast.
Yes, okay.
The REC deliberated upon the proposal and examined the proposal in DSS. The committee observed that the total land required for this project is 239, which includes 35 of revenue forest and 203 of non-forest. Out of 35, the state government has recommended 34 forest land for diversion. Committee decided to recommend regularization of the area of forest land over which construction activity has already been done in violation of Forest Conservation Act, and balance forest land proposed shall be maintained as green belt. The committee opined that the state shall furnish the exact extent of forest land. Let us kindly see the kind of people who are there. All well as high-powered members of this high-powered body, which is well as specifically entrusted with this task. It is not that kind of a rapacious, insensitive, negligent well as approach to environment which your Lordship finds. In this case, for sure because I am a completely well unconnected party. I have inherited it, no doubt. It is my responsibility, no doubt. I must satisfy my Lord's conscience, no doubt. But because that does make a difference if he's the person who did it or I am the person.
For how many years they are in the occupation of that forest land? That is one of the concerns. They did not apply earlier for this regularization of their land. When the public interest litigation was filed, only then they filed the proposal for regularization. And 30% they did not take care to inform the court that the process is going on.
Now, I must say this. I obviously cannot, as they say, I can be visited for my father's sins, but not for my predecessor's sins. I have fortunately taken charge only in 2018. 2022. No, sorry. 18 to 22 is the moratorium, right? No, 18 to 22 is my IBC proceeding, the moratorium. Actually, my charge is 22. So in December. Now, your Lordships, I mean, I must apologize for the fact that people have been perhaps lying or letting lie.
Appreciate our concern. Concern is pattern and method.
Well, I am going to suggest something which I am not for a minute going to suggest something which will violate your Lordship's concern. I am the most sensitive that I started. Suppose. Well, just forget me going ahead. I have not come to IBC yet. It's very important. Forget this case. Suppose your Lordship will agree, I hope, subject to my Lord's kind discretion, that hypothetically there are any number of cases where forest land diversion is allowed. Forget this case in Tamil Nadu, in Assam, in Nest. The object is that a project be not held, but environment be compensated, right, fellows? Now, today the highest body but one, after this there is only one body, has recommended, this recommendation is not easy to get. This may or may not fructify. Even after it fructifies, I am prepared to say it ultimately comes to my Lord's scrutiny. There will be always other challenges in this country. There is no problem about challenge. People have access to the court. There will be. Now, I am asking myself the question of balance of convenience without asking a Lordship to go into the merits. What has happened has happened. I can't rewind. I can't turn the clock back. But A, nothing has happened after 22. B, suppose your Lordship were to have a standstill. I'm only thinking aloud with your Lordship's kind permission. Suppose your Lordship were to have a standstill. That of course, I have to say so myself without your Lordship saying so. I am saying so. I will not touch these 0.533 or even 35 in terms of any activity. 195 doesn't arrive, it's a non-forest land. So I will not even lay a sapling or a piece of stone. Now, two things can happen. It can't be that for something as high as a 226 court in the High Court of a state, once your Lordship opines by a comma full stop, no authority can touch me. It's obvious, fellas. But now suppose I was, apart from a Lordship's order, had your Lordship not passed the order to get this, is it not a better balance of convenience to then come up and see whether it's a way out, it's a correct way out? Or perhaps then, your Lordship may still stick to that view. But how is it, in any manner, protecting the balance of convenience if I have to do everything now? There are towers, there are constructions which I have purchased as SRA. I have not made them. Now, if it is removed,
question that how this property can be shown as the property of that corporate, which were under the scrutiny of a legal proceeding. This is a completely a forest land.
What has happened is that there is encroachment. Encroachments do happen, and demarcation, etc.
Yes.
Encroachments do happen. I mean, there is a encroachment, which is why, there are two categories. Let me tell you one more thing. There are some kinds of encroachment which can't be regularized. Your Lordship appreciates that. There are some special no-go areas now. They are called red zones. There are also one of the areas which are reserved forests. I don't remember fully, but there are many such areas where it's a per se doctrine you can't regularize. Why have you created this regularization scheme? Only because this is the other category where nobody is saying that you should willfully go and do an encroachment and then come for regularize. That's not the case. If there is something, you may regularize. Now, I am asking myself one question. What additional harm in any manner is caused by simply having a standstill statement recorded by me, seeing where this process stops, and then seeing the whole position later? Well, it can't be in any manner prejudice to. Now, see the reverse. Everything I have to move. It's a massive exercise, for the 35 hectares especially. It's a massive exercise. And I get tomorrow my regularization. That means in law, I'm entitled to regular Lordship knows, even a chhajja in my house, which is illegal, and that is much more intentionally done. And it is not that the chhajja is being dealt with by a subsequent purchaser. I'm a subsequent purchaser. Your Lordship does regularize. So, which is the balance of convenience is a question I'm asking myself with greatest humility. I'm saying, certainly your Lordship will lose nothing in public interest because your Lordship is the custodian in 226 PIL of public interest. As a matter of fact, your Lordship is not concerned about him, that he brings it to your Lordship attention. I don't mean the AG, I mean the PIL petitioner. Your Lordship get something your Lordship notice, your Lordships can balance the equity in whatever your Lordship likes. So therefore, that's my first point, and I end it by pointing out two more things. Therefore, one is the earlier order of a division bench of this court. It is not that I am without any order. Second is the recommendation I just read.
The earlier order, that is pointing out that the 1st July was given this date for the decision. That was never, nobody was
that taken care of straight away. You are also with the 226. Let me not go down the technicality. You are also with 226 court. Invite him if your Lordship to add a line that this pending decision be decided within 4 weeks, 6 weeks, 8 weeks. I mean, we are not playing a game of
that direction. We will not give. That your approach regarding, we are just
I can say that I will approach immediately and get it expedited more. However, my interest to be late. Kindly consider. For me,
regarding the regulation procedure, nothing before us. So why should we pass?
No, it is in a sense. In a PIL jurisdiction, your Lordship is not hedged in by technicalities. In a PIL, what your Lordship is concerned.
So let them do their work. We are not interfering.
No, that's all right. I'm not saying. I'm saying since your Lordship is concerned that there is delay, your Lordship just rightly opined that your Lordship saw some May, then your Lordship saw some July. Now things may not be moving as fast. These things happen. I will, of course, as I go out of court, certainly be obliged to approach them with written documents of pushing it.
No, I think
it might help a lot of
at least filed an affidavit that is the scenario. This could not be done within the time granted by the court. There was no such approach before this court.
Well, now I have read to your Lordship the actual document. It can't be better.
No. Right now, before passing of the order, it was the duty of the corporate to place this that is already in session, and that's within a short while.
That is why, let me tell you very candidly, I believe in being candid with the court. Well, an order by a Lordship is appealable to Supreme Court. The first thing I have told when I was approached was that we have to go back with everything and put it before the learned division bench to consider the whole thing. Because it's not fair unless your Lordship at sea gets a chance to see everything. So it's not that we are also just rushing around. That it happens sometimes. These are not ex post facto documents created for this purpose. No, these are genuine situations.
We are not even expecting also.
I am saying today, if there is no adversity there and a possibility of resolution here, then it's a win-win for everybody. Because at the worst, I will not get it. The matter will stand back. At the worst, I will get it. Your Lordship will consider it. It's with respect, something which is on balance of convenience entirely one-sided in my favor, if I may be permitted to say so. And just note as I end on this, two things. Regularization is a very, very heavily regulated activity, as the word itself says. One is guidelines are issued. And they are one of the most detailed guidelines. Also, will turn to that because I want to complete regularization at one go. The guidelines are at page 159. And they are massive. The relevant guideline is at 159, 1.21. But otherwise, there's a whole book on how to regularize, why not to regularize. And the book starts with the minister's statement at 154, 155. I'm not reading
see 159 only.
Yeah. 159. No, I don't need to. Your Lordship is not a regularizing court. Your Lordship is not an appellate. I'm just saying there is a scheme for it.
Okay.
I will fall or stand as per the scheme. It's not granted easily. They say rarest to rare cases. The guidelines say. Actually, for me to get this recommendation is not easy. It has taken considerable time. The word at 159 is rarest to rare. I read it first. Except, I'm sorry, it says exceptional circumstances. Does my Lord have para 1.21? Exceptional. So, the threshold is not easy. Why? Rightly so, rightly so. As a custodian of public interest, even this authority must not keep the threshold easy. And therefore, 160 again, gives your lordships in double I all kinds of cases. Now, this is the next point. Next point is don't think that regularization is so easy that I apply and I get it and walk away. There are penalties provided. 5 times the NPV is mentioned there. I am not troubling the lordship with the nitty-gritty. My lord is not reviewing. But if and when that happens, is it not better to give that chance with possibly or not exhaustive discretion to add a sentence to say let it be done in a time-bound manner, or I will in any case approach. That's point one. Point one. Point, and one more thing before I end this. Regularization is a time-tested technique by the Supreme Court also. Your Lordship will just note Electrosteel Limited, a Supreme Court judgment of 2023, just a few months ago. Volume 6 SCC 215. Specifically, it's very interesting context. You also need to spend 2 minutes on this. It's an intersection of errors and regularization with the IBC. Because I am saying all what I have said applies a for sure when I am a newcomer who is not responsible for the violations. I am trying to sort out something which is not of my making. And therefore, regularization is the right approach for this. There are 72 of this bunch I have handed over. Does my lord have it? 72. Yes. There can be no doubt the need to comply with. So, this is a very important case because a direct Supreme Court judgment of an intersection with environmental concerns and IBC, identical to my case. There can be no doubt that the need to comply with the requirement to obtain environment clearance non-negotiable. A project can be set up or allowed to expand subject to compliance. Environment clearance is granted on the condition of suitability of the site to set up the project in the environmental angle, existence of necessary infrastructural facilities. To protect future generations, imperative pollution laws be strictly enforced. Under no circumstances can industries which pollute be allowed to operate unchecked and degrade. The question is whether an establishment contributing to the economy of the country providing livelihood to hundreds of people should be closed down for technical irregularity of shifting its site without prior environmental clearance, without opportunity to establishment to regularize its operation, without opportunity to the establishment to regularize the operation by providing requisite clearance permissions, even though the establishment may not otherwise be violating pollution laws. The central government is well within the scope of its powers under Section 3 to issue directions. Such prior environment is necessarily granted upon examining the impact. Now mark the next sentence, fellows. Ex post facto environmental clearance. Now this is the worst case, fellows. Yes. There was no clearance at all. Mine is a case of encroachment. Clearance is not question. Ex post facto environmental clearance should not ordinarily be granted. Certainly not for the asking. Same time, ex post facto clearances, approvals, and or removal of technical irregularities in terms of notifications cannot be declined with pedantic rigidity, oblivious of the consequences of stopping. The 86 Act does not prohibit ex post facto environmental clearance. Some relaxations even grant of ex post facto EC in accordance with law. Strict compliance with rules, regulation, notification, appropriate cases, where the projects are in compliance with or can be made to comply with environmental norms, is in our view not impermissible. That's a double negative. The court cannot be oblivious to the economy, etc. Now just note one more parameter that I'm done with this case and with the topic of regularization. That is Manus para 86 on the penultimate page of the last page actually. In passing the implementing order, the High Court overlooked the consequences of closure of an integrated steel plant with a workforce of 300 regular and 700 front. Mine is a stronger case. I'll just show in a minute. In a minute, fellas. The High Court also failed to appreciate the judgment of this court in alembic. Furthermore, continuance of the interim orders allowing operation of industrial establishment, even the grant of a revised DC, cannot stand in the way of action against that establishment for contraventions, including the imposition of penalty on the principal polluter pays. The scope and effect of 32A, which I'm just yet to come to, but I've not yet come to, is very important, is a different issue. This court need not examine the question whether penal action can be initiated against the appellant or whether compensation can be recovered from the appellant at this stage. The issue will be decided by the appropriate authority at the appropriate stage when it adjudicates an action for penalization of the appellant or recovery of compensation, etc., etc. This is, Malas, point number 1. I am saying, Malas, on this point alone, if your lordship were to simply defer the implementation of your lordship's directions and await something, it would meet the correct ends of justice. That's my point 1. Point 2, Malas. Okay. The IBC, Malas, has a twin effect, and that's important. It has a twin effect, which is my point 2 and 3 connected in a sense. The first effect is that does the plan, which involves taking up of this property by the successful applicant, does it specifically mention this infringement? And if the plan deals with this very situation and is then approved first by the COC, in this case by 86%, then by the 31A regulator, well as the NCLT, and then in cases challenged up to the Supreme Court, then, Malas, that acts as a binding on all in rem extinguishment of that issue. So there is one facet of IBC which is extinguishment, in the felicitous words of Justice Nariman Malas. Otherwise, it will have hydra-headed monsters popping up for Malas unwary newcomers like me. The second aspect is even more important because it was done by a statutory creation and amendment. Well, what happened was, Your Lordship, just give me a minute here because the rationale is very important. Well, ultimately, and I had the privilege, of dealing with the first 5 resolutions. Well, Your Lordship knows this IBC came in 2016 by what is known as the dirty dozen. There were dirty dozen, 12 companies identified as well as very badly in debt. So the dirty dozen led to actually the enactment of IBC. 5 of those resolutions, I've been a part of. The 5 of those resolutions, it was found that, for example, I did the matter where Tata's took over Bhushan Steel. They also took over SR. This JSW took over another Bhushan company. Now, when you take over, there are also, apart from the various usual illegalities, there are defalcations also. There are frauds also. And there are criminal prosecutions also. Now, it is nobody's case that the Tatas or the people who come in have done it. It is nobody's case.
Let us your point number 1 for the time being.
Well, it's because this is little important too.
I understand these are the ancillary issues.
But these are issues which will arise only if I need to argue them in the event that your lordship decides to defer it for a while and see the outcome of regularization. Then your lordship is right, they will not arise right now. But because I don't know whether I should proceed or not, I'm in your lordship's hands. But because in the event that this is deferred for a while, regularization by itself is the correct balance of convenience without a jot of harm on my affirmative statement to this honorable court that I shall not touch these 2 parcels of land. Okay. On 32 and the other one, I'll not take time. I'll just take 2 minutes more since your lordship has indicated. Well, it's 238 of the Act overrides. Your lordship in 4 judgments, of which I may be allowed to read a para of 1 only. Manish Kumar, 2021 Supreme Court, I'll give the copy. Ghanshyam Mishra, which I had the privilege of arguing, also 2021. And of course, the well-known Innovative, the first case, where I had the privilege of fighting for the losing petitioner, and some other cases. They all say, one thing, that if the plan mentions it, then it extinguishes everything. Now, the clean slate principle. Now, just note, this issue of encroachment is specifically covered in the plan. Specifically. It is in pages 265, 267, etc., that this issue is directly part of the plan, which is approved. And therefore, under innovative is binding in them. In 32A, Manoj, just pick up the section itself and just see for a minute. 32A bracket 2 bracket A without going. The section itself says that for such penal consequences, please don't catch the new man. It's as simple as that. Otherwise, look at the irony. I am supposed to be a knight in shining armor saving somebody, and I get saddled, and this is happening actually. Even PMLA authorities are coming. Just see 32A. I am not condoning what my predecessor might have done. I am not suggesting that. But certainly, the Lordship will see that I have a preferred equity over him. 32 capital A, bracket 2, bracket explanation. Just see those two lines. Kindly hand over to my ladyship of the IBC. They will copy or save. Extra you another copy, no? It was to be an indemnity. May I read it slowly for my ladyship? She doesn't have it, so I can just read it slowly. No action shall be taken against the property of the corporate debtor. May I read it?
Yes, it is quoted in page 45 of our IE.
I'm told it is quoted at page 45 of my IE also.
Oh, yes, there?
Quoted in 45. I hope correctly. 45 of the IA which I am arguing. Manish Kumar. 32 capital A. Your Lordship notes it came in specifically to protect such people. Otherwise, nobody will come. Why will I come to resolve a dispute? In 2020, Malas, from 28/12/2019, early 2020, it started operating. And the section says 2. May I read this?
Yes.
No action shall be taken against the property of the corporate debtor in relation to an offence committed prior to the commencement of the corporate insolvency resolution process of the corporate debtor, where such property is covered under a resolution plan approved by the AA, that is the NCLT, under 31, which results in the change of control of the corporate debtor to a person or sale of liquidation assets who was not A, promoter in control of the CD, B, a person with regard to whom the relevant, it is nobody's case, fellows. I am unconnected, I am a newcomer. Now see explanation. So I am completely a newcomer. For the purposes hereby clarified that an action against the property of the corporate debtor in relation to an offence shall include the attachment, seizure, retention or confiscation of such property. Well, before I argue the matter before your lordships, if I am supposed to wipe the slate clean by demolition, then what is left for me to argue, Willis? And please note, Manish Kumar's evocative words, which are there, just see, give it to him, give it to my lord. Just see only one para in Manish Kumar, which is, all the four are important, I'm only reading one of them. In para 321. Actually, 320 to 329, 9 paras are important. I won't read any of them. Just read one. One is 321 of Manish Kumar. Give it.
Already give 320.
Directly on this, fellows. Can your lordship note on the side? Your lordship is in this jurisdiction the custodian of public interest in 226.
Yes, yes.
So this is most apposite for me to say to the 226 court. The resolution plan settles 5,081 crores. 5,081. Well, after all, that's also public interest. Your lordship has NPAs of lakhs of crores. Your lordship has employment issues. 5,081. 82% affirmative vote. It gives 1,000 crores upfront and it additionally invests 1,650.
1 minute, please hold. Your paragraph is 321?
Yes, 320 it starts. So 320 summarizes section 32 capital A.
Yes.
I need not read it, your lordship has noted it. Then 321 italicizes. See the second half of 321. Since the word include is used under subclause 1 of explanation, the word action against the property of the corporate debtor is intended to have the widest possible amplitude The Supreme Court saying this. There is a clear nexus with the object of the court. The other part of the clarification is found. But if this is so, and your lordship is asked by anybody to ignore the balance of convenience and proceed to clean it up, then this point will become infructuous. It will actually be of no relevance. And why is this passed? Our case is the best example, Just note 3 facts. It clears a debt of 5,000 crores. Additionally, it has an infusion of 2,600 crores. Employment is huge. Plus, there is a clause in the MOU of 7th of February 09 that I will supply guaranteed power to Orissa of up to 14% of the output in case they ask for it. Okay. So it's not that and for that your lordship created 32A. This is not my case. Any case a person comes, he has to be protected. Otherwise, why will he be like a knight in shining armor? So I am saying these are all and public interest facets are many. I am in a bit of a dilemma. I don't want to take a lordship's time to argue. I am saying if your lordship were to simply at the moment defer it, simply deferment of the operation, which is otherwise, we filed the application before 15 days. We filed the application before your lordship 15 days. We filed it immediately. We mentioned it also. I am told lordship. So, the lordship may consider. Otherwise, all these points, which I am not fully argued, could become infructuous. I am very deeply aware.
Anyone from the petitioner's side?
It is. Everything started after December 2022 onward. The damage which has been done, the forest growth which has been damaged since 2014 to up to 2018. Yes. Who will compensate this minor? And overnight, the structures were not built. State government was slept over the matter. And the concerned authority
slept, or they are collaborating with them. Who can say that?
They should have taken steps, yes, to stop the construction work. The huge construction have been constructed overnight. That is not possible. So, my lord, the state government, the concerned authorities should be penalized for that. Some action must be taken against them.
No, we are focusing only one point, because this application has been filed. Their contention is very simple, not that go for a standstill for a certain period of time, because a proceeding is going on, and there is, you can see it's evident from the proceeding records of this committee. So their apprehension that we are going to lose the use of this damage in a way the property, even the next day the regularization is permitted, then what will happen? Only this request is they will not operate anything. It will be under the standstill, and nobody will be allowed to expand and go inside this. They're just waiting for this. What is the resolutions committee decides? And thereafter, and they have ancillary issues is because this IBC, because they have this, I do not know whether the project was approved by the state government, because this land was part of that project. State government was a state directly. Their knowledge. I don't think so.
No, in the plan. My lord is asking the plan. The plan mentions this.
This encroachment part was the part of the IBC.
Yes, that's the reason why extinction applies.
Okay.
Directly at page 265, 264, 267. Directly. So there are two separate aspects of IBC. One is 32A, which is penal.
Page 84. Page 84. Resolution plan.
Resolution plan directly, your lordship, very lordship, take it. I've checked it out. Has it?
265, 266.
265, 266, as I said. So that's the separate facet of IBC, namely extinction. This is the 32A aspect, which is penal.
Who is appearing for the state government? You have nothing to say? No, Advocate General is a part of this problem also. He has given some suggestion.
No, that was my predecessor.
Okay.
But if your lordship saw page 159 and 160, that post facto approval, that also has a lot of penalty. It's almost 5 times
the different penalty, because What is the argued today is very categorically argued, but not without giving anything that you can just lay the focus only one point.
Right.
If there is a possibility of the post facto approval or not, that is not our business to
Correct, correct.
It is the committee will do. And what will be the consequence that will follow, we are not going to.
What Dr. Singh essentially is arguing is, give me a chance to get it. If I get it, then I get it.
That he says, don't give me even chance, but look into this, the proceeding. If tomorrow I get the regularization and today you say that it will serve nobody's purpose. Yes, it is nobody's purpose. But if it is after post facto approval is granted, is forced to pay something, that is a different issue. We are not.
That should be right. Right.
I want to know what the state governments stand in this matter.
Right. We will monitor and ensure that they don't touch anything till the approvals are granted.
No, that's what they have offered.
No, we'll have to monitor. They have offered, but we will have to monitor and ensure that it is what they say is compliant.
No, that is a allegation of the petitioner is a little bit disturbing.
Yes.
Because you are just sleeping over the entire issue since 2014 where they started construction.
But we did some encroachment cases and we
how the construction is started. You are not guarding the forest area. How that can happen? After this Balco case, I think at least state of Orissa should be very cautious. And
no, you should be right.
So, Mr. Singhvi, that what we propose, that we'll just keep that what is a proposal, stand still, no entry, no change in the structure. Nobody should be allowed to operate from that part of the land. If it only just to repeat, I would request you that three plots actually.
Yeah.
According to you, there is a 3 plots.
Two only, and
we are concerned with only
0.533 HA and
just 0.335
0.533.
0.533.
And the second is 35.985. It is common ground and there is no dispute about the area. And your lordship, if it's so minded, my lord, then your lordship can record my submission that I suggest, because I'm not running away from it. I myself made the submission that I do not intend, to give this a chance to work itself out. I don't intend to touch it. There's no question about it. He is, of course, welcome to have his binoculars on me. I have no problem.
So that order will pass, not in the courtroom. We are dictating order.
Very well. Very well. But your lordship, just touch upon the lordship's earlier order. Otherwise, I would be in contempt. I don't want to be in contempt.
Keep that order
obliged, in abeyance, etc.
It is on hold. It will be.
I'm very deeply obliged. I'm very deeply obliged.
Monitor. Only to that extent with the conditionalities that we have discussed.
Yes. Okay. One last thing is, I'm not insisting on it. It's your lordship discretion. It actually meets the ends of justice for everyone, including this court. If your lordship wants to add a sentence to push along the regularization decision.
No, that is not.
It can be decided schedule. It helps everybody. You produce
this approach.
Some remedial measure. Real approach.
No, that is the committee will decide.
Very well. I appreciate it. Deeply obliged.
Other matter.
Your lordship is reserving orders.
Not reserving, you will pass in the chamber dictated up.
Right.
Very possible today.
Very.
No, Mr. Singh, just for a moment. How much time should we wait tentatively? 6 months? 6 months should be fair.
As minimum, good to see your lordship knows the way government. It's not my control at all. As a matter of fact, I am a newcomer, so it's worse. But 6 months, is very fair.
Minimum it for 6 months is reasonable.
Very fair and reasonable. I'm obliged, very deeply obliged. Item number 24.
What do you have?
Will I appear for the petition? I have
My Lord, may it please your lordships. My Lord, I've handed over a list of dates and submissions, my Lord, so that my submissions are more precise. My Lord, what I intend to do is take your lordships to the list of dates, and wherever I need to show some document, I'll show to your lordships.
My Lord, the state has filed additional affidavit. We have received a short for instruction. We don't have. If Attorney General is complete argument, I have nothing to say, but they have filed and they have said that the state is to.
There is a adjournment.
Yes, my Lord.
A prayer for adjournment.
Yeah, so it's better, my Lord, because you'll start the argument is unnecessary time. That's why.
Is not getting us because he's unmute.
There is no difficulty. Your lordship can take the affidavit on record.
Would affidavit file to you? Would it?
Yes. Same.
They must have something. Yes.
Additional affidavit has been filed. That is already on record.
My Lord, this is also had it, please.
This is not the additional affidavit.
Yes.
This one. Yes.
Yes, my Lord,
yes. So, you want to take instruction. I think today we cannot complete also.
No, my Lord, we are okay with the affidavit. Your lordship can take the affidavit. It's a
Okay.
point which I have already. So there's no difficulty, my Lord. My learned friend can proceed, and I'll assist my lords with my lord's permission. Tomorrow I'm already there to rejoin conclude the matter. Grateful.
Yes, my Lord. My Lord, the state government, my Lords, this is 23rd of August 1991. The state government issues a notification calling for applications for grant of mining lease for iron ore over so and so hectares in Keonjhar district. My Lord, has the first date. Kindly see the second date. Under Rule 22(1) of the Mineral Concession Rules, the petitioner OSIL applied for grant of mining lease for iron ore. My Lord, these words are a little important. To meet the captive requirement of its existing iron ore plants in Paraspanga, Keonjhar, and proposed sponge iron plant at Bamra and Sambalpur. Kindly note, my Lord, these are very important because it said that I'm putting up, I need this iron ore for these two plants. In its application for mining lease, it was specifically mentioned that iron ore from the mining lease will be utilized for captive use in its sponge iron plant. So that was also very clear. But on 29/12/1997, as a matter of abundant precaution, the state government sought the following information from the OSIL. Specific proposal for consumption of this mineral in your plant showing requirement of iron ore for the year. Kindly note below, iron ore for the year. What will be your annual requirement? In response to the state government, OSIL reiterated that it had applied for mining lease, kindly note below, for consumption of iron ore in our existing sponge iron plant at Palaspanga and also the upcoming plant at Bamra. So what it represented to the state is that we need this area for meeting the captive requirement of these two plants. Yes. But based on the commitment of OSIL to use iron ore exclusively in its existing and proposed plants, the state government issued a recommendation as per section 11(3)(d) of the MMDR Act 1957 as it stood before 2015 amendment for the grant of a mining lease to OSIL over 459 hectares in village so-and-so Keonjhar for 20 years and sought for the central government's approval under section 5(1) of the MMDR Act 57. In the recommendation, it was specifically mentioned, this is very important, there is a total requirement of 2.2 million tons of iron ore for their own consumption per annum. There is an estimated reserve of 108.77 million tons of iron ore in the applied for area, which will take a minimum period of 50 years to run the plant at the consumption of 2.2 million per annum. But the calculation is this. You will require 2.2 millions every year for your plant. You will be given a lease for 50 years. This is 20 and another renewal for the rest of the period. So therefore, 50 multiplied by 2.2 would roughly work out to about 100 plus millets, and therefore 100 is what it has. But am I clear, Lords? 2.2 is your annual requirement. Yes. I am going to give it to you for 50 years. So that roughly works out to close to 108, and therefore a captive lease. Now, here, if your Lordship don't mind, kindly see section 11(3)(d). What is 11(3)(d)? We are now talking in terms of a recommendation and an approval, both of which are statutory. And if your Lordships I've given a compilation so that your Lordship don't have to go to the book. At page 4 of this, section 11 is there. The scheme is like this. Under the MMDR Act, the state has to make a recommendation. No mining lease can be granted without the recommendation of the state government. And that recommendation of the state government, my lord, is the statutory recommendation. And your Lordship may kindly see page 4, my lords. My lords have page 4 of this compilation. Yes. Preference section 11(1), preferential right of certain persons. Your Lordship may skip all that and kindly come to, my lords, 3 at page 5. Lord, what the scheme is like this. If you come first, Lord, if you have prospected that area, you have a preferential right under 11(1). 11(2), if you are an earlier applicant, you have a preference over a later applicant. 11(3), if there are simultaneous applications, how they are to be dealt with. Now, 11(3), if your Lordship sees, 11(3)(d), the matters referred to in subsection 2 are the following. Any special knowledge or experience in reconnaissance operation, prospecting operation, mining operations, as the case may be, possessed by the applicant, financial resources, nature and quality of technical staff employed or to be employed by the applicant, and B, investment which the applicant proposed to make in the mines and the industry based on minerals. So therefore, when I make a statutory recommendation here, I rely on 11(3)(d). Here is an applicant who has come and he says that I am going to put up industries and I am going to expand my existing industries. The area has about 100 million tons of ore. His requirement in 50 years is more or less the same. And therefore, I prefer it over all other applicants. Now, my lord, if your lordship sees the recommendation, which is at page 42, I'll just take 2 minutes with that, my lords. Because the submission is that the approval under 5.1 has to be in line with my recommendation made under section 11.3. If your lordship sees page 42 of the brief, my lords.
Yes.
Let me read page 43, top of the page. My lords have it. Out of the 43 number of simultaneous applications, only 14 applications were found to be suitable for consideration of grant of PL/ML, prospecting license mining lease, on availability of area as indicated in the comparative statement enclosed. So 14 good applications were there. But why we chose Odisha Sponge was, Odisha Sponge had applied for grant of mining lease for iron ore over so-and-so hectares in village so-and-so to meet the captive requirement. You should underline that.
Yes.
To meet the captive requirement for their existing sponge iron plant at Palaspanga of Kenjhar district and proposed sponge iron and pig iron hot metal plant at Bamra in the district of Sambalpur, the sponge iron plant at Palaspanga with installed production capacity of so-and-so under expansion production capacity of additional 3 lakh metric ton requires 8 lakh metric ton of iron ore per annum. So also the proposed sponge iron plant and pig iron hot metal plant at Bamra with production capacity of so-and-so in 2 phases will require 14,000 metric ton of ore. Thus, the total requirement of 2.2 million tons of iron ore for their own consumption per annum. There is an estimated reserve of 108, which your lordship saw. So my recommendation was, my statutory recommendation was that his requirement for the proposed plant and existing plant would be roughly about 100 million ton, and this is what it has. And I make a recommendation. Well, on 17/7/2002, if your lordships come to page 2 of the list of dates, my lords, the central government conveyed their prior approval under section 5.1 of the Act, subject to compliance of the provisions of the MMDR Act and rules, Forest Conservation Act 1980, environmental notification dated 27/1/1994. So what was lacking was, my lords, an approval under Rule 27.3, which would permit me to insert a captive condition in the lease. But am I clear, my lords?
Yes.
The application is for captive. My recommendation is for captive. And therefore, I as state, when I recommend or decide to recommend somebody in exercise of my statutory power, and I invoke my statutory power to recommend for a captive lease, I must have an approval to insert a captive clause in the lease. Now, kindly see, my lords, note, as per section 5(2)(b) of the MMDR Act, a duly approved mining plan is a prerequisite for the grant of mining lease. That your lordship saw the other day, my lords. Since the state government had issued a recommendation for captive mining, not merchant mining, prior approval by the central government under section 5(1) of the Act must necessarily be accompanied by an approval under Rule 27(3) of the mineral concession rules, so as to restrict the lessee from using the ore otherwise than in his own industry. Well, the intention was to give it for merchant mining, I could have considered the other 14. There were 14 applicants. I chose one because he said I will use it for my own factory. But on 26/8/2004, OSIL entered into an MOU with the state government, wherein parties agreed that iron ore from the mining block will be used for captive plant. The petitioner also undertook to expand its existing sponge iron plant at Palaspanga, Kenjhar, and set up a new sponge plant at Bamra. So he enters into a MOU even after the 5(1) approval has come. without a captive clause. Note, clause 5BV of the MOU provides that the grant of mining to the petitioner shall be exclusively for captive consumption. Further, clause 5BB1 also stipulates that the petitioner shall expand its existing sponge iron plant and set up a new unit as a condition precedent to the grant of mining lease. Now, at 27/9/2004, the state government issued a letter to SIL offering the terms and conditions which shall govern the grant of mining lease. The process is this: I recommend, Government of India approves, I give terms and conditions, he accepts, and that will be followed by a mining lease. Yes. The terms internally included, the mineral exploited from the mining block shall be exclusively utilized for captive requirement of the existing and proposed plants. OSIL shall undertake its expansion of the existing proposed plant as per the MOU's time schedule. The above conditions, this is very important. The above conditions shall be subject to the central government approval under Rule 27(3) of the Mineral Concession Rules. And if you actually just see, page 55 of the brief, just that clause, at page 55 of the brief, my lord, sir, page 55. The terms conditions which I gave him are at page 52. My lord, sir, page 52, my lord.
Just a minute.
Yes, sir. Yes.
Page
5 to 27/9/2004.
Yes.
Must be bookmarked in your register. Yes. Annexure 4, my lord. Kindly see, my lord, the first paragraph. I am directed to inquire, my lordship Savitri. I am directed to inquire whether you accept the following terms and conditions that would govern the grant of mining lease in respect of the application read over or an area of so-and-so, village so-and-so, as per the enclosed formula, pro forma, which should reach the government before 25/10/2004, failing which it will be considered that you do not accept the conditions. Now, kindly see page 55. The last paragraph. My lord, there are several conditions which are set out from page 52. I'm sorry, my lords, I'm taking your lordship back to page 52. If your lordship sees, my lord, page 52, Roman 1, and we go on till page 55, which is Roman 17. My lord Savitri.
Yes, yes.
And kindly see, my lord, the last one. The conditions stipulated in para so-and-so are subject to approval of the Government of India under Rule 27(3) of the Mineral Concession Rules. And kindly see, my lord, what he does. This is, if your lordship sees the next date, my lords, 27/9/2004. I come back to the list of dates, serial number 9. In terms of the state government's recommendation dated so-and-so and pursuant to its letter dated so-and-so, the state government sought central government approval under Rule 27(3) of the Mineral Concessions Rules 1960 for the captive use of iron ore from the mining block of OSIL in its existing units. So I write to them. On 4th of January 2024, in reply to the letter dated 27/9/2004, Annexure 4, your lordship just saw, my lords, of the state government, OSIL accepted all the terms and conditions to the mining lease offered by the state government, which says OSIL unconditionally accepted that it shall use the ore from the mining block for exclusive captive use, expand its existing setup, proposed plant, and the mining lease is subject to prior approval of the central government under 27(3) of the Mineral Concession Rules. But may I show you lordship page 56, Annexure 5. Annexure 5, my lords, page 56.
Yes.
Subject, application dated so and so of Messrs. Orissa Sponge Limited for mining lease over an area of so and so. Your letter number so and so. Please find enclosed the duly filled up acceptance of the terms and conditions offered by the state government of Orissa in your letter referred to in connection with the grant of mining lease over so and so in village so and so so and so. Best regards. And if your lordship sees page 57, form of acceptance. My lordships have it. Very next page. Page 57, my lord.
Yes.
To so and so, I so and so, Managing Director of Orissa Sponge Limited, and legally authorized person to communicate its acceptance on behalf of the company, do hereby accept all the terms and conditions laid down by the state government, White Steel and Mines letter dated 27/9/2004. That is Annexure 4. So they accept, I do hereby agree that I shall abide by all the terms and conditions laid down as may be amended from time to time in the Amendment Act 1997. So therefore, they accept that this lease will be subject to me getting an approval under 27(3).
Yes.
My lord, the next date, if your lordship sees, my lords, is 24th of March 2005. My lord, as I told your lordships, that one of the condition of the approval under section 5 was that you must get all the clearances.
Yes.
And that, if your lordships want, my lord, I'll just show that letter for a second. Approval 5-1. If my lordship sees Annexure 2, page 45, 17th July 2002. This was the approval, my lord, 17th July 2002, page 45, Annexure 2.
Yes.
My lords have it, my lords. Kindly see the second paragraph. Before allowing grant of mining lease, the state government may ensure the compliance of the amended provisions of the Act and rules and other applicable acts and rules, including Forest Conservation Act, Environment Notification, so and so, etc., etc. Now, kindly come back to, my lords, page 87, 24th of March 2005. Lord, one of the essential requirements for granting a mining lease is set out under section 5(2)(b) of the Act.
Yes.
Section 5(2)(b) of the Act, my lords, says in the compilation, my lord, it is at page 2. It starts at page 1.
Yes.
Of the compilation. My lords have it, minutes?
Yes, yes.
5. Restriction on the grant of prospecting license or mining lease. And if my lords kindly comes to 5(2)(b), which is at page 2, no mining lease shall be granted, 5(2), by the state government unless it is satisfied. B. There is a mining plan duly approved by the central government or by the state government in respect of such category of mines as may be specified by the central government for the development of mineral deposits in the area concerned. So therefore, mining plan is a condition precedent. Now let us see what is the mining plan they have. If your lordship sees the list of dates, minutes,
yes,
the mining plan is serial number 11, 24th of March 2005. That is at page 87. My lords have it. This is Indian Bureau of Mines, 24th of March 2005. Subject is approval of mining plan for so and so. And if my lords kindly turns to page 89, my lords are page 89, my lords. This is a document dated 24th of March 2005.
Yes.
And the last paragraph is Roman 10 at page 89. My lord says, have it.
Just a minute.
I'm sorry. I'm so sorry.
You are referring to page 89.
My lord, 87 it starts, the mining plan. So I have shown your lordships, my lords, under the scheme of the act, mining plan is one of the mandatory documents which are required for executing a lease deed. That your lordship saw under section 5(2)(b). Now let us see what is the mining plan they have, because they are saying we need to execute mandamus for execution of lease. Now if your lordship sees 87, 24th of March 2005, it will be page 87.
Yes.
In your lordship's file.
87.
Yes. So my lord, it is 24th of March 2005.
Yes.
And kindly see, my lords, it is by Indian Bureau of Mines to so and so, subject approval of mining plan of Malanpalli iron ore deposit over an area of 459 hectares in Keonjhar district of state of Orissa in favor of Orissa Sponge Limited, submitted for grant of mining lease under Rule 22 of the Mineral Concession Rules. So now IBM is the authority to grant the mining lease. It examined the application for grant of mining lease filed under Rule 22 of the Mineral Concession Rules, which was the second document in your list of dates. In the list of dates, this is serial number 2. There is a reference to Rule 22, and the mining plan also refers to Rule 22. And after examining the application, because the application was for captive, at page 89, the IBM says that this mining plan is subject to compliance of the terms and conditions stipulated in item number so and so to so and so, that your lordships have already seen, and very important, and 2 of the state government dated so and so before execution of the lease deed. So now let us see what is 2 in that letter. And if my lords kindly sees, my lords, page 52 here, annexure 4, page 52. Annexure 4, page 52, my lords.
Yes, yes.
At page 55 is that paragraph 2. I'm sorry, I'm taking your lectures back and forth, but this is very important.
All right.
Because the IBM mining plan says that it is subject to a condition that you get an approval under 27(3).
Yes.
So my submission to your lordship is that even assuming they had some kind of right under 22C, there is no mining plan, and the mining plan which is there, it says it is subject to 27(3), and therefore, on the basis of this mining plan, no lease can be. Okay. Now, your lordship may see, mills, on 4th of July 2005, now I come back to the list of dates, serial number 12, the central government did not grant its approval under Rule 27(3) for captive condition. The state government apprised the central government about its statutory recommendation in favor of the petitioner for grant of mining lease and the MOU with OSIL. It again sought for central government's approval for grant of mining lease. My lordship, my learned friend has shown this to all these to your lordships.
Yes, yes.
On 8th, 12th, there is a refusal. But on 3rd of June, the stage 1 approval for the Forest Conservation Act happens. Now let us see what that document says. Kindly see, my lords, page 99. Page 99. And it is dated 3rd of June 2013. This is the forest approval. So we saw IBM approval was hedged with the condition that there should be a 27-3 approval. And now we come to forest. What does the forest approval say? That is page 99.
Yes.
Your Lordship, sir, page 99, minutes.
Yes.
It is to the Principal Secretary, Forest, Government of Orissa, Bhubaneswar. And if my lord kindly turns over the page, minutes. Kindly see Roman 11 and Roman 12. My lord, sir, 11 at page 100. Roman 11 and Roman 12. My lord, sir, page 100, minutes.
Yes.
Yes. Roman 11, the iron ore to be raised from the mine shall be utilized exclusively for captive use of the existing as well as the proposed sponge iron plant, steel plants of the user agency. In no circumstance, the user agency will be allowed to sell/export the iron ore raised from the same. So mining plan says it will be subject to 27(3). The forest clearance says that you cannot sell and it will be only for your plants. And if my lord sees now 12, the user agency shall within a period of 5 years from grant of stage 1, that is 5 years from the date of, this is grant 1, this is from 3rd of June 2013, that is 5 years at the end in 2018, expand capacity of their existing plants or install new plants to utilize 4 million ton MTPA of iron ore as stipulated to be raised from the said mining lease. Stage 2 approval and diversion of forest land, including the extent proposal, will be accorded only if the user agency submits a definite plan in this regard. So submission 2, the forest approval is also subject to a captive clause.
Yes.
And what is a captive clause and what is 27(3)? If your lordship takes this book, minutes.
Yes.
There is a mineral concession rules, 1960. There is a mineral concession rules 1960. If your lordship sees page 63, minutes, if you are holding the same book, your lordship may see page 61. My lord Justice Ratha has this book. Are we holding a different? This is the one I am holding. My lord, your lordship see page 60 or page 61, my lord? Mineral concession rules 1960.
Yes.
Kindly see page 61. These are conditions. Every mining lease shall be subject to the following conditions. And your lordship may see 27(1) goes on till my lord, till end of page 63. So therefore it is 27(1)(a) to 27(1)(u). My lord Savit, my lord?
Yes.
And kindly see 27(2) is over the page at page 64. My lordship Savit, my lord?
Yes.
The mining lease may contain such other conditions as the state government may deem necessary in this regard, mainly. So these are additional conditions. Now there is nothing in 27(1) and 27(2) which authorizes the state government to make it a captive lease. So therefore under 27(3), kindly see now 27(3). This is the 27(3) we are talking about. The state government may either with the previous approval of the state government, central government, or at the instance of the central government, impose such further conditions as may be necessary in the interest of mineral development, including development of atomic industry. So therefore, if you want to impose a condition which is not there under 1 and 2, you have to take either the prior approval of the central government.
Yes.
So when an applicant is coming to me and saying that I need it for captive and not for anything else, then I need a 27(3) approval to insert that clause in the mining lease so that the mineral is not used otherwise. Well, let us say I grant the lease him today and tomorrow he sells the minerals. Then I have no control over the lease. Therefore, I need to impose a special condition in the lease deed to say that it will be only for captive. Well, while your lordships are here, kindly see Form K. And that your lordships will get minutes at page. What is this?
Form A we have seen on the earlier occasion.
My lord.
Form A we have seen.
Form K, my lord. Form K is the mining lease deed,
125,
which is at 125. It starts at page 125. In the same book, my lord. My lords have it. My lords have page 125 of the same book, my lord. This is mining lease, see rule 31, Form K. And if my lords kindly turns to minutes.
Just 1 minute.
I'm sorry.
Yes.
Yeah. And if my lords now kindly turn 2 minutes, there are various parts of this lease. If your lordships comes to page 126, part 1, area of the lease, my lords have it. Page 126. Just the next page.
Yes.
Part 1, area of the lease. Part 2, just below that, liberties, powers and privileges to be exercised. Part 3 is page 128, restrictions and conditions as to the exercise of liberties. And part 4, liberties, powers and privileges reserved to the state government. Part 5 is rent and royalties. That is page 130.
Yes.
And 131, my lord, covenants of the lease. Now, these lease covenants are what is set out in 27(1). If you want to add 2 and 3, then for 3 you have to get a prior approval. So therefore, if I had to add something here in part 4, namely captive, then there was a necessity for me to get a prior approval. So I have shown to your lordships that the mining plan said it will be subject to a captive clause. The forest clearance said it will be only for captive. And I don't have a captive clearance till now. Now your lordship may next see minutes 16, 12th of January 2015. The MMDR Act was amended with effect from 12/1/15 and the Amendment Act Section 10A was inserted, added to the Act. Now on 1/8/2015, I again write to the central government that give me approval under 27(3).
What is that communication?
That communication, your lordship sees minutes, is at page 62, Annexure 8, 1/8/2015. Your lordships had seen 2 refusals before. And what was argued is, with the second refusal, the matter is attended a quietus. Now it has to be followed. Now on 1/8/2015, after the amendment, I write a letter on the 1st of August 2015, which is Annexure 8, page 62. My lord, minutes. Kindly see page 63. This letter is being written at the highest level paragraph 7, and I won't read it. Your Lordship may just see para 7, and now kindly see paragraph 8. Thus, the special condition regarding expansion of existing plant from so and setting up of a 8 MTA plant have not been approved by the central government. However, the applicant company has accepted the terms, accepted the conditions. Besides, the MOE of Government of India in the letter dated has also taken note of the captive use of minerals and conditions of expansion and installation of the new plants in stage 1 approval for forest clearance. The applicant company has not objected to such reconsideration of the conditions of these conditions so far. And if your Lordship sees para 9 minutes, it is pertinent to mention here that 29 PLML applications for iron ore and manganese over villages while rejecting other applicants, the ML application dated India because it was for captive use of mineral within the state. Besides, the application of the applicant company had expressly mentioned the purpose of lease to be captive use within the state. These two are very relevant factors justifying imposition of special conditions in the grant order, which have perhaps not been taken into consideration by the Ministry of Mines. It is therefore requested once again that the proposal of the Government of Orissa for imposing the special conditions returned back by the Government of India in the letter dated may please be reconsidered and approval thereof for imposition of special condition be communicated to this department early. But kindly turn over the page minutes. 9, 10, 25, next page. This is 9, 10, 2015. I reiterate my same request once again. And this is page 65, 9, 10, 2015. My Lord Savitri. Yes. And kindly see now at page 16, now Government of India is responding. So it is as if, not as if, that the Government of India said that there is an end to the matter. Kindly see 66. 20th January 2016, Secretary Government of Orissa, Department of Steel and Mines, imposition of special condition to grant of mining lease for iron ore over an area of so-and-so. I am directed to refer to the Government of Orissa letter dated so-and-so on the subject above and request you to provide the following. The status of the target milestones listed in the MOU dated so-and-so to give the present installed capacity and pledge future capacity and the requirement of work for 50 years. The details of the reserves of the said area to specifically state the reasons for the delay in processing the proposal by the government. My Lords may kindly turn over the page minutes. At page 67, 2nd of February 2016, I write a detailed letter to them replying on all these points. That your Lordships will get minutes at page 67, 2nd of December 2016. I write a detailed letter. And my Lord will now see page 241. Annexure F by 1. Of my counter. Annexure F by 1, page 241 of my counter. Running page 241. Yes. But this is dated 20th of January 2017.
Just 1 minute. I'll find out the page. 241.
Yes. One second. 20th January came. Not there in this letter. No, that was right at the that was right. No. My Lords have minute, page 241.
Yes.
This is annexure F by 1 minute. Now the government of India is writing to me. My Lord Justice authorized. Now let me read it slowly. Secretary, Government of Orissa, Department of Steel and Mines, imposition of special condition to the grant of mining lease over an area of so and so in favor of Orissa Sponge Limited. I am directed to refer to the Government of Orissa's letter dated 9/10/2015. Your Lordships have seen that letter just now. 9/10/2015 was serial number 18 of my list of dates. Annexure A by 1 minutes. To say that the status of consideration of the MOU may be detailed by giving the action taken by Government of Orissa after the application of the project proponent for extension, the following points may be clarified. Whether extension of MOU for more than 7 years is provided in the existing MOU, and if so, whether legally permissible, and the existing terms and conditions are relevant and the proposed to be issued. Whether OMC, your Lordships have to read this as this company, Orissa Sponge. Whether Orissa Sponge's future installed capacity has been arrived at by the state government against the requirement of the next 50 years and satisfying them, please provide. You are requested to provide intimation to the ministry for further process. So therefore, my lords, correspondences regarding 5-1 approval was in vogue as late as 20th of January 2017. So therefore, to say that my 5-1 approval has attained a finality and therefore I have a 1002C right, in my humble submission, my lord, is premature.
Okay. Submit the complaints to the party.
Yes. If my lords kindly now come back to my list of dates, my lords. If your lordships comes to serial number 20, on 4th of March 2016, the Mineral Concession Rules 2016 came into force. Rule 8 stipulates the process for saving applications under 10(2)(c). On 2nd of December, the state government responded to all the central government queries. In particular, the state government stated OSIL had not complied with the terms and conditions agreed upon in the MOU, and by the letter dated 4/10/2004, OSIL had not set up the proposed plant at Bamra and had not expanded their existing power sponge unit. In terms of the MOU, the capacity of the existing plant is only 2.5 TPA as opposed to the promised 4.5. So this is the last letter to the government. Now the last on serial 22, 17th December 2016, OSIL submitted a compliance report purportedly under 8.1 of the MCR 2016. OSIL admitted that it had not expanded its existing capacity at Persminga unit, not set up the new unit at Bamra, and it has already accepted the conditions of captive rule clause with the state government. The lecture may see page 77, annexure 12. Well, this is post-amendment.
Is we have already.
My lordships have that letter, my lords?
Yes.
Now this letter, kindly note, my lord, is post the amendment. It is 17th December 2016. Your lordships have it, my lords? That date your lordships will get just below the Orissa Sponge
number.
Yes, I'm grateful. Just below the reference number. Compliance report and terms and conditions issued by so-and-so. We have already accepted the terms and conditions issued by our good office on 27/9/2004. That your lordships have already seen annexure 4. Yes. We are submitting the compliance report of the above terms and conditions which is enclosed. It is kindly requested to issue acknowledgement of receipt of compliance to us in schedule so-and-so. Kindly refer to 8.1b of MCR 2016 within 3 days. But what 8.1b said was, that if you have complied, you write a letter and they will respond to it. And only then it will be followed by a mining lease. But what is important is, if your lordship sees just below that letter, there is a CC mark to Director of Mines. My lords have it, minutes. Page 77.
Yes.
Dr. P.K. Manti, and then there are two enclosures. And kindly see CC, Director of Mines, Government of Orissa, for kind information. And just see the one below, Secretary Mines, Ministry of Mines, Government of India. My lords have it, minutes. Just below, CC, Director of Mines. My lords have it.
Oh, this page?
Page 77.
Oh, that
yes.
I've seen, yes.
Kindly see at the bottom, CC, Secretary Mines. Secretary of Mines, Ministry of Mines, Government of India, with a request, he kindly look into the matter and facilitate us in executing the mining lease with the Government of Orissa. We have already accepted the condition of captive clause with the state government. So till 17th December 16, 1 year after the amendment has come in, they are writing a letter and marking a copy to the Government of India and saying, please give us the captive clause so that this lease can be executed. This is very important.
Yes.
So both the state government as well as the lessee, intending lessee, were on the same page that there was a requirement of a captive clause for me to take the next step for granting a mining lease. Forget my letters. The lessee himself says that I am now requesting the Government of India to kindly expedite the matter so that the lease can be facilitated, and we have accepted the condition of captive clause with the state government. You know, by this time, tenancy 2C has already come in 15. They are not saying there was a 5-1 approval. I have all the approvals, give the lease to me. No, they are writing to Government of India that for facilitating this lease, you have to give us a captive condition.
Oh, it was examined.
But we'll do it, lordships. Well, I think tomorrow there will be a separate bench. Because Justice Ratho is retiring, you normally have the last day.
No, yes. There will be.
I don't know, minutes.
My lord, in cases tomorrow I'll be grateful.
It will be. Yes, Mr. Jain.
In cases tomorrow I'll be very grateful, my lord.
So I was only requesting, lords. I'm sorry.
I'm already there, so I'm grateful to my learned friend and to the bench. If your lordship could accommodate, we can complete the matter then.
I will take about an hour and a half, minutes at least.
I'll take half an hour.
Tomorrow, this will be difficult, I think.
Yes, yes.
So we have to go some other day.
My lord, I am available any day after 13th.
13th,
14th, 15th, any day.
14th. 14th will do it. Subject to Mr. Jain. 14th.
But whatever is convenient to have.
All right, make it 14th.
So it's 14 minutes.
No, Shah. 15 is a Friday.
My lords have a difficulty on 14th, 18th minutes.
18th.
18th minutes. 18th.
Okay.
18th, 2 p.m.
But anyway, we can be squeezed in tomorrow, my lord, somehow. As they sometimes say, last ditch effort.
No, tomorrow there will be some problem because tomorrow there will be the second half and then we are planning to have a.
Well, one of the learned judges is retiring tomorrow. So we have a reference in the afternoon.
So we will be taking on 18th.
Yes, my lord. Lordship pleases. 18th, 2 p.m.
Keep it on 18th list. For continuation of hearing, list the matter on 19th. This is it. West Porter. Give the slip of the appearance.
Right. Yes, yes.
Now, item number 16.
My lord, item
16,
number
madam.
14.
Interim order may be continued.
Item number
408.
Interim order is passed.
Item 16, madam.
Last Saturday. I can only give you a date tomorrow because I have a bench, another bench.
Yes, another bench, Lordship. Lordship granted leave, Lordship. So if it is not possible today, tomorrow, first half 10:30, because the other side has filed contempt petition after the filing of the appeal, getting the notice and got it disposed also with the final order that we have to comply within 4 weeks. I don't know how it happened, Lordship, but I have to place it before your Lordship.
This tomorrow, huh?
My lord, pardon to mention, my lord. Item 25 ultimate order was till today, my lord. Okay, not taking my papers.
Listing on 5th of October. When the interim order is passed early, it shall continue, huh?
Item 28 interim order is till today.
29.
28 and 29.
Same order, huh? 5th of October.
And also item 37.
All right.
My lord, item number 20. 12. Item number 12. My lord, I filed a writ appeal 913. It was in person and it was not in proper manner. So honorable court had it was not in proper paraphernalia according to court's direction. Honorable, I had again filed in another.
You remove the defects that you have identified.
Yes, sir. All defects. Sir, defect I have another file 187623. It was not in proper manner for the annexure problems.
So you filed a new case. So what is he saying?
I have filed a new case.
No. ତାଦେହରେ ଡିଫେକ୍ଟ ରିମୁଭ୍ କଲେନି ଆଉ ଗୋଟେ ନୂଆଟେ ଫାଇଲ କଲେ
ଆଜ୍ଞା ମ୍ୟାଡାମ
ନୂଆ ରିଟ୍ ଅପିଲ ଫାଇଲ କରିଛନ୍ତି
ଆଜ୍ଞା ଆଜ୍ଞା
ସେଇଟା ଡିଫେକ୍ଟ ଫ୍ରି ଅଛି
ସେଇଟା ଡିଫେକ୍ଟ ସବୁ ଠିକ ଅଛି ସେମାନେ କହୁଛନ୍ତି ଯେ ଆପଣ ଯୋଉ ଏସଆର ସେକ୍ସନ କହୁଛି ଆପଣ ସାର୍ଟିଫାଇ କପି ସବୁ ଦିଅନ୍ତୁ ଯୋଉ ଅନଲାଇନ
ହଁ ସେଇଟା
ଫାଇନାନ୍ସିଆଲ ଇନେବିଲିଟି
କୋର୍ଟର ନିୟମ ସେଇଟା ନହେଲେ ଗୋଟେ ଦରଖାସ୍ତ ଦେବେ ଯେ କଣ ପାଇଁ ସେଟା ଦାଖଲ କରିପାରୁନାହାନ୍ତି ଗୋଟେ ଦରଖାସ୍ତ ଦେବାକୁ ପଡିବ dispensing with filing of certified copy ମାନେ ଅସୁବିଧା କହିକି କାହିଁକି ଫାଇଲ କରିପାରୁନାହାନ୍ତି ସେଟା କୋର୍ଟ ଆଗରେ ଆସିଲେ ବି ସେ ଡିଫେକ୍ଟ କନସିଡର କରିପାରିବେ
ମ୍ୟାଡାମ ତ କମିଂ ଭିତରେ ଆସିବା ପାଇଁ ରିକ୍ୱେଷ୍ଟ କରୁଛି କୋର୍ଟ My lord, excuse me, another problem. CRL to 1565 मोटे apply करथिली माननीय कोर्ट रे कोर्ट नंबर 6 रे मेंशन करथिली से पुणी अपन कोन असाइनमेंट प्रॉब्लम बाय कोर्ट नंबर 7 को पळीथिला किंतु मैडम हे परली हमको मो 4 थर अपन मेंशन करली किंतु एटा लिस्टिंग हे परन
Orders item number 1. No, this is an application for restoration matter. Due to network problem, the County Council for the petitioner was not present before this court when the case was called for my lord. So the honorable court was paid to dismiss the writ. Where is Mr. Devakant Mahanti? Not here. My lord. Okay. Sir, can I have your plan for the fighting? No. Go ahead. Even 1, 2. I am given the something. File is not available. Restoration. Mr. Month, 3 months.
Restoration of the BC that's an which is dismissed with the order which is 15 to the report for purpose action. So, there is the obligation. This is stated that for the conduct of the and this council before the shall not be made to suffer, and non-appearance was inadvertent and not intentional. So, again, regulatory substantiveness of justice. We recall the order dated 15/2023, passed in WC 7271/2023, and electrically said in terms of the group presentation and the law is posted. Next.
Item number 2. Yes, your sir. The present petition, the restoration against the dismissal of writ appeal, WA having its number 652 of 2022, which got dismissed on 8th May. 8th May, your lordship. 8th May. Sought the copy of the restoration application. That's the reason why the file is not. Now, sir.
Remove the defects as shown in the step report.
Let's say some curable defects. It is a curable defects, but copy be sought in the course of day. Maybe recently, I'm solving the copy. But I don't have. Yeah, let's see. I'm not available. Just I'm going to sort the copy. I don't have an objection for restoration, but if you have an explicit department, non-possible. Paripana must be maintained. I'm going to serve the copy.
This is not that casual running process. Maintaining a proper procedure in the court.
Yeah, let's see.
It's not the Friends Club.
No, yeah, let's see. Just some defects.
Remember that.
Yeah, let's see. Okay.
My lords, I am on VC, my lords. I am for the state.
Any objection? In your absence, I took the assistance of Mr. Kadokia
My lord,
This is time for siesta, so he has left the court.
my lord, copy has not been served on us yet, but your lordship can.
Mr. Jena. This is Jena.
Yes.
And also we came on to the change the order. Explanation of each every number.
652 by 2023.
It was dismissed by the
8 May 2020.
the order dated 8 May 2023. None of the report. It's unintentional. Not me. No, yes, second, I think.
85. So it's correct.
85.
No, this was just 85%.
The 19th of October 2023. Let's take the one of
Item number 3.
Please, your lordships. My lord, the matter was on 4th July, my lord. I was dirty, my lord. I was suffering from high and throat infection, my lord. Therefore, I could not be present on call, my lord. Of course, I have sent one of my associate, my lord, who was a newcomer. By the time she reached, my lord, orders were already passed for engagement of legal aid at council, my lord. I have filed this recall petition, my lord, for I may be allowed to conduct this case, my lord. As this is a criminal appeal, my lord, a private appeal.
We are not recalling the order.
My lord?
We are not recalling the order that we have permitted you if you appear only there. If anyone doesn't appear on the next day also, this order will continue.
My lord, I am appearing in this case, my lord, for the appellant, because the appellant was present, is present now in the court, my lord, pursuant to the order of this honorable court of the last order, due to the lordship of glance. And pursuant to that order, the appellant is also present here, my lord.